Yes.
May I please? For listing of RSA, your lordship,
When?
for order
When?
24th, 4th April.
4th April.
Yes.
May I please? Yes.
Please, your lordship. Wait for listing MSc appeal. Next take any date here. MSc appeal here.
Pardon?
MSc appeal for listing MSc appeal. Any date here next week here.
Next week.
Any date.
Okay.
Before BU.
Hearing.
For BU. Hearing. Hearing. 10th. 10th. Maybe Mr. Lordship, I beg to mention item number 15, Lordship, of daily list. Lordship, maybe fix next week or after 1 week, Lordship.
The pair being made by Mr.
NH Lashkar.
N.S. Laskar, Learned Counsel for the petition, raises a list the matter
After BU, maybe.
after due vacation.
I love it.
May I please, your lordship? Lordship, I beg to mention item number 27, your lordship. I am for the respondent, your lordship, appearing on Mr. A. Ganguly, lordship. Madam may be listed, your lordship, after 2 weeks, your lordship. Any date.
Mr. Your good name, please. Your good name, please.
P. Chetri, your lordship.
Mr. P. Setri, Learned Counsel appearing on behalf of Mr. A. Ganguly, Learned Counsel for the respondent. You inform the other side
Yes, your lordship.
Yes, Lordship, input applicant.
with consent from the other side, press for listing the matter. When?
After 20 April, your Lordship.
20 April.
20 April. On 25th April.
Apply. Much of it.
May it please your lordship. Lordship, I beg to mention for listing of an interest case, lordship. Can
When?
it be fixed on 2-4?
Can.
Oh, hearing.
No, for orders. Obliged.
May it please your lordship. Lordship, I beg to mention item number 26, lordship.
Yes.
My lord, my only prayer is that can the matter be fixed after Bihu vacation? Ma'am?
Okay.
Fixed
That's
date may
agreed
be-
by learned advocates of both the parties. Rest is the matter after due vacation.
My lord, may it please, my lord. With regards to item 33, my lord, I beg to mention item 33, my lord.
Mr.
A. Deka, my lord.
A. Decker, Learned Counsel for the applicant. Press for listing the matter. When?
After two weeks, my lord. After
After 2 weeks. Fair look.
May it please your lordship, I pray for listing a CRP matter
When?
on 1st of April
First April.
for motion
Not first April. This is the 2nd April.
on then 3rd of April.
Lordship, on hearing day. So many.
Part of April,
Seventh of
not
April.
hearing day.
2nd April. 2nd.
7th of April.
7th April.
Yes.
What's up?
May it please your lordship. I beg to mention item number 2.
Item number
2.
2.
My senior is out of station.
Who is your senior?
Fix the matter after 1 week.
Who is your senior?
D. Borua. Mr. D. Borua.
On the pair being made by Miss. Your good name, please.
Miss S.K. Gupta.
S.K. Gupta, Learned Counsel for the petitioner. Rest is the matter on
After 1 week.
after 1 week.
After 1 week.
May I please your lordship? Lordship, I am praying for listing of an MSc appeal, lordship.
When?
Lordship, 1st of April. It's for orders, lordship.
For
Orders, lordship.
order.
Yeah, please, my lord. With the consent of the other side, I beg to mention item number 16 and 17, my lord. It may be taken after my lord 2 weeks.
You are for the respondent.
I'm for respondent in item number 16.
Okay. As agreed by learned advocates of both the parties, raises a list these two matters after
2 weeks.
2 weeks.
Lordship, in item number 17, there is an interim order.
Okay. Interim order in
Item number 17.
item 17 shall continue.
Your lordship, with the consent of the other side, I beg to mention item number 18, Lord.
18.
Your lordship, kindly the matter may be adjourned and a date
Okay.
may be fixed.
Miss, your name, please.
B. Hajarika on behalf of our
Miss P. Hazarika, Learned Counsel for Counsel appearing on behalf of Ms. R. Chaudhary, Learned Counsel for the respondent.
respondent.
With consent from the other side, press for listing the matter.
Any date in the month of May, Lord.
Okay. After 4 weeks.
Your lordship, kindly a date may be fixed.
7th. Come from the promotion, become one order matter.
May I please, Lordship?
Yes.
Yesterday also I contacted with Deputy Commissioner of Duguri.
Hmm.
It's same position, Lordship, fund is yet to be released from the GAT department.
Okay, I'm related to the GAD well. But what happened was our name is not reflected well, so we were not.
No, your name is not there.
Last my lord, we even have a copy of the case. Well. So my lord, I think my lord, the last occasion my lord, he had produced some document. Document produced where it is in process. He had given well. Where it?
No, unreleased order is there.
That order we.
Mr. Gogoi has already submitted, but ceiling is not given.
Ceiling is not.
One more, my lord. I don't take it. He take it up on the next week, my lord. I'll take it.
No, not next week.
Because my lord, we are handicapped because I have not been given a brief also. We were not a party in this case.
No, you are not party, but I have requested Mr. Gogoi to
Please not.
discuss the matter with you and to obtain instruction.
But I think the copy, my lord, with the.
Okay, we'll take it up at 2 o'clock. In the meantime, Gogoi, this is fund release order. A copy of the fund release order will be furnished to you. At
Can
2.
be on Monday, man. Monday.
No. Not Monday.
Item 3.
Monday is holiday.
May it please your lordship. Lordship,
Yes.
may it please your lordship. Lordship, this is a transfer petition. We are praying for a transfer of matter that is a matrimonial suit pending in the
From
court of
whose
Tinsukia,
place to
lordship.
whose place?
Lordship,
From whose place to whose place?
lordship's title matrimonial suit from Tinsukia district to Guwahati family good lordship.
You are
For the wife lordship.
wife.
Wife lordship.
She is staying at
She's
the
staying
Guwahati
at Guwahati at her parental house.
and
and- And the
respondent?
husband is staying at Tinsukia lodge. There are,
So husband has instituted the proceeding.
he has instituted a divorce proceeding in the Tinsukia district court lordship.
So what is the ground?
Lordship, the grounds are there. She is having some mental disability, mental problem. Disorder was there. She was curing herself there at Tinsukia. Now she had shifted to Guwahati. And this is the ground my husband has taken to oust her out of the matrimonial house. So we had been living over here with our parents, we being the wife. And now, Lordship, she has instituted a DV proceeding and a Assam State Commission matter. Lordship, 2 of the summons where we have instituted a suit of DV, that is at Annexure C. Page 16, Lordship. This DV proceeding we have instituted at Kamrup, Guwahati, Lord.
Page number
Page number 15, Lordships.
15.
15, Lordship.
This DV proceeding is in Guwahati.
In Guwahati. DV is in Guwahati. And Lordship, the other thing is that there is Assam State Women Commission matter that has also been instituted. That is at page number 11, Annexure B. And if I-
What is this? The suit is pending there.
Lordship, that it is issues in Tinsukia District Court, Lordship. That it is at the stage of issues. We have just confirmed, Lord. The last date was 26, Lordship. And more properly, at para number 13, we have made a specific amendment that she is undergoing a mental treatment at Guwahati, Lordship. She is taking treatment, para 13. Page number 6, Lordship. That the petitioner begs to state that she is suffering from some health issues for which she is taking treatment in Guwahati, that the petitioner is living with her old age parents and the father of the petitioner is bedridden and suffering from various illness, and the respondent is fully aware about the same. But he has instituted the suit on this ground that I am mental patient. And I was having some treatment at Tinsukia, now I have to shift to Guwahati for a better treatment.
Third, Mr. S. Betala, Learned Counsel for the petitioner. This petition under section 24 of the Code of Civil Procedure is preferred by the petitioner for transfer of title suit. within bracket matrimonial number 79 of 2024 pending before the Court of Learned District Judge Tinsukia. To the Court of Learned Principal Judge Family Court, Kamrup M. Guwahati. Ms. Betela, Learned Counsel for the petitioner, submits that the petitioner is the wife of the respondent, wife of the sole respondent, who resides at Tinsukia. And due to some ailment, the petitioner is in Guwahati and undergoing treatment. And the respondent herein has instituted one divorce proceeding before the Court of Learned District Judge Tinsukia. Mr. Betela further submits that it is difficult on the part of the petitioner to contest the aforementioned proceeding at Tinsukia, and as such, there is a requirement for transferring the above-mentioned titles of matrimonial number 79 of 2024 to the Court of Learned Principal Judge Family Court at Guwahati. And therefore, Mr. Betela contented to allow this petition. The submission of Mr. Betela needs further consideration. At this stage, notice be issued to the respondent returnable in 4 weeks. Step be taken by registered post with AD and also by usual process continuing from today. Until returnable date, further proceeding of matrimonial titles of matrimonial number 79 of 2024 is pending before the Court of Learned District Judge at Tinsukia stands state. List of proposals.
Deeply obliged.
Item one.
Lordship, I just been informed, my lord. The Lordship has the thing, my lord. GAD has, my lord. Initially, they were not able to do it because this thing came late to the GAD from the Deputy Commissioner's office. Therefore, that time, my lord, during financial year 2024-25, this thing could not be cleared. Now, my lord, however, budget has been augmented by way of reappropriation made by proposal number so and so, and subsequently has been distributed by so and so for an amount of rupees 9,22,180. That means, my lord, in this financial year, now it will be given. So I have spoken with him also. So if we can fix this matter on say 1st of May or something like that, my lord, by then maybe the amount will be cleared, because it will go to the next financial year. The money which will be sent to him, will be paid to him. Already the augmentation has been done, ma'am.
Yes,
In the first week
I'll
of May,
give
my
you a copy also, ma'am.
1st of May.
first week of May, my lord. Any date, my lord. Any date, first week of
Okay.
on 5th or 6th.
Till then I'll get my instructions also. How far it's gone. Till then I think it will be clear also, maybe.
No, why the amount would not be released during this financial year?
Because, my lord, at that point of time, the Deputy Commissioner's office sends the proposal. I mean, my lord, it is given from the Deputy Commissioner's office to the GAD for proposal. And this thing, my lord. So it came late, most probably. Something happened, my lord. It came late, because of which, my lord, it could not be covered under the financial year 24-25. That's what it. And also, my lord, because there was no fund available at that point of time. With reference to the subject cited above, I am directed to state that no fund was available in the proper head of account bearing so and so during financial year 24-25 for payment of dues of the petitioner. However, budget has been augmented by way of reappropriation made by proposal number so and so, and subsequently budget has been distributed by so and so for an amount of rupees so and so. That is the amount which he is to get, 9 lakh. So he will get it. This is itself speaks for itself.
Heard Mr. D.N. Bhattacharya, Learned Counsel for the petitioner, and Mr. Gogoi for the respondent number for the respondent. And also heard Mr. A. Pupon, Learned Standing Counsel for the GA department.
No, it's February. ঠিক আছে পয়সা
Mr. Mr. Fukun, learned standing counsel for the GA department, obtaining instruction, written instruction and place the same before this court. Then submits that budget for the amount of rupees 9,22,180 rupees has already been distributed. Distributed, and the same will be paid within a month. And press for listing the matter in the first week of May. Care of Mr. Fukun is accordingly allowed. Press shall list the matter on first of
9th May, Lordship.
9th
9th.
May. The written instruction, which is placed before this court by Mr. Fukun, shall be part of the record.
Lordship, registry may reflect our name, SCGAD in the contest.
The registry shall reflect the name of Mr. A. Fukun, learned standing counsel for the GA department in the cause list.
Deep privilege,
Public.
Item number 4.
Please, Your Lordship. Lordship, this transfer petition delayed for the transfer of the matrimonial suite from Baska to the Principal Judge Kamrup Metro Guwahati, Your Lordship. Is I am the resident of the Lankeshwar Guwahati, Your Lordship. I got married with the petitioner, who is the resident of the Baska district, Musalpur, Your Lordship. And the after marriage, we resided there, and thereafter he was transferred to the Dibrugarh. And while we are in rented house at Dibrugarh, some extramarital affairs was developed by the respondent with some other lady. Some dispute was going on between the parties, and he started to cause torture upon the present petitioner. And after that, while I was in the with the petitioner till up to 7/1/2025, the respondent, he came to Baska and filed his matrimonial suit on the 2nd of January 2025. And after filing of this case, the respondent has chased me out from the Dibrugarh, and since thereafter I am residing at my parental house. I am having a heart patient, Your Lordship, and he lost the instituted suit at Baska. It is not possible on my part to travel to the Guwahati to Baska, and so far the
Mr. Mohan, Baska is just 2 hours journey from here.
Lordship, but I am my open heart surgery was gone, and I was even after as on date I am under medical treatment, Your Lordship. And so far the maintenance suit I have filed because he is not providing as on date any pay to me in the name of livelihood, and accordingly a maintenance case is going on before the Principal Judge Family Court Guwahati, Your Lordship. And because of that reason, Your Lordship, my family, I am residing in a very poor financial condition. I don't have even effort to go to the Baska to appear before the trial court, Your Lordship. That is why I have to file a petition before the Kamrup Metro, Your Lordship, Family Court Principal Judge for seeking maintenance, Your Lordship. And he is a government service holder. Only I am living with my mother. My father is also expired in the year 2021, Your Lordship.
So you have also filed another
Lordship, that was filed. That was withdrawn, Your Lordship. I have annexed this case because of some technical reason, Your Lordship. Technical defect, Your Lordship, is there. It was for transfer of this petition, but so far the cost title and other portion, it was projected that for restitution of transfer of the restituted petition for file for restitution of conjugal land, Your Lordship. I have enclosed this order also, Your Lordship.
Heard Mr. L. Mohan, learned from Court of Appeal. This petition under section 24 of the Code of Civil Procedure is referred by the petitioner for transfer of ES within bracket M case number 01 of 2025 filed by the respondent under section 13(1) within bracket Roman 1 dash small a of the Hindu Marriage Act 1955, which is pending before the Court of Learned District Judge Baksa, Musalpur. Mr. Mohan, learned counsel for the petitioner, submits that the petitioner is the wife of the respondent who instituted the above mentioned proceeding at Baksa, Musalpur. Further, Mr. Mohan submits that the petitioner got married with the respondent and thereafter lived together as husband and wife at Dibrugarh,
Lordship.
where the respondent was serving as
Is serving as, is a government under the Health and Family Welfare Department.
in the Health and Family Welfare Department at Dibrugarh. And there, marital discord surfaced between them, and thereafter the petitioner has been residing at her native place at Guwahati. And thereafter, the respondent has instituted the divorce proceeding at Baksar. And the petitioner is suffering from some ailment and undergoing treatment. Then her financial condition is also poor. And on account of the same, it is practically difficult for her to contest the suit at Baksar. And therefore, Mr. Mohan submits that the title suit, certificate M number 01 of 2025, pending before the Court of Learned District Judge Baksar Musalpur, may be transferred to the Court of Principal Judge Family Court at Guwahati. And therefore, Mr. Mohan contended to allow this application. The submission of Mr. Mohan needs further consideration at this stage. Notice be issued to the respondent, return in 4 weeks, may be taken by registered post AD and also by usual process within a week from today. And considering the submission of Mr. Fukan, Mr. Mohan, learned counsel for the petitioner, and also considering the facts and circumstances of the record, further proceeding of title suit M number 1 of 2025, pending before the Court of Learned District Judge Baksar Musalpur stands state. Please after for it.
I'm highly objective.
Similarly, place matters were listed before your lordship on the 21st. They pertain to, my lord, judgment in our transmission line at various locations from a court at Hilakandi, my lord.
So you have already paid a sum of rupees 7,08,853 rupees.
My lord,
Already paid.
we have paid, my lord. We have part payments were made. And after that, they had filed the concerned cases under section 10 and 16 of the Telegraph Act, my lord, for an enhancement of compensation. So our main grievance here is, my lord, that the enhancement which has been done under the principle of future profits, my lord, which is alien to the Telegraph Act. Because we only have the right of a user over the said lands, my lord. And as a user, we are only paying for the surface damage and tree crop compensation, not compensation in any manner, my lord, which will be linked to future profits. My lord, 21st, 4 CRPs no move, and they have the judgment has been stated therein, my lord.
Heard, Mr.
N. Khera, my lord.
Then Khera, learned counsel for the petitioner. And also heard Mr. Gogoi for
Respondent number 1, Lordship.
learned standing counsel for the respondent number 1.
And GA Assam, Lordship.
This application under Article 227 of the Constitution of India is directed against the judgment dated 23rd 11/2023, passed by the learned additional district judge Hailakandi in Miss PG case number 03 of 2018, dated 23rd 11/2023. It is to be noted here that aforementioned judgment, the learned additional district judge has directed the petitioner herein to pay a sum of rupees. What is the amount?
My lord, another 3 lakhs,
3 lakhs.
3,80,000.
In which paragraph of your petition you have mentioned it?
My lord, the judgment itself says, my lord. My lord, page number. My lord, page number 50 is the judgment.
Page number?
50, my lord. 50, the judgment starts, and the operative part of the judgment is at page number. My lord, page number 71, my lord.
It is mentioned as 9,42,416.
My lord, to be paid. Another.
The similar matter also came up, I think last 21st of March, before the Honorable
Okay,
Justice. He was-
Directed to pay a sum of rupees 9,42,416 to the respondent number 2. Here, to the respondent number 2. Mr. Khera, learned counsel for the petitioner, submits that the petitioner has already paid a sum of rupees 7 lakhs
My lord.
8,853. And after payment of the aforesaid amount to the respondent number 2, he had prepared one application under section 16, which in bracket 3 of the Indian Telegraph Act 1885, claiming additional compensation for the surface damage and prospective child losses. And thereafter, the learned additional district judge by the order dated 23rd/11/2023 has enhanced the compensation amount
10,57,581.
and also directed that the amount shall carry 6% interest per annum. Mr. Khera further submits that the impugned judgment is arbitrary and illegal, and therefore it is contented to set it aside. The submission of Mr. Khera, learned counsel for the petitioner, needs further consideration. That is this notice be issued to the respondent, returnable in 4 weeks. However, no formal notice is required to be issued to the respondent number 1 since Mr. Gogoi entered appearance and received the notice. However, extra requisite copy of the petition be furnished to him during the course of the day. Step upon respondent number 2 be taken by registered post with AD and also by usual process within a week from today. Registrar shall call for the record from the learned trial court. Please the matter after 4 weeks. Where it is mentioned,
My lord.
where it is mentioned, this demand of 3 lakh rupees
10 lakh, my lord. Para 10. Para 10, my lord.
of your petition.
My petition, my lord. Page 7 and 8. Demand is for 10 lakhs, 57,581, my lord. My lord, that is the total demand that was granted. We have paid, my lord, an amount of 7,08,853. The balance amount is 3,48,728 and on top an interest of 1,40,159. This would be in the demand notice, my lord, annexure 5, page 84, the summary.
Page number?
84, my lord, para annexure 5.
No, not from the demand notice. You saw from the judgment where it is mentioned.
My lord, page number 66, my lord, judgment. My lord, at entry 17,
Yes.
my lord, entry 17A, 6,59,200. B, 1,60,000. C, 1,20,000. D, 68,000. E, 19,000. F, 12,000. G, 18,000. My lord, H is the total component. A to G, 10,57,581, my lord.
Where it is mentioned.
At page 67, entry H, my lord. Page 67, my lord, is the judgment, the operative part at entry H.
Yes.
10,57,000, my lord, 581.
Mm. Uh, 10,57,581. Then out of this amount, you have already paid 7,08,853
My
rupees. 53. And considering the submission of learned counsel for the petitioner, and also considering the facts and circumstances of the record, the impugned judgment and order dated so and so is state till returnable date, list of the province.
One submission, Lordship. Similar, several matters is listed before the court number 14, last 21st of March. Similar matter, Lordship. I think I could not find a order, Lordship. That was dismissed,
Appeal.
Lordship. Similar matter,
No, this is revision petition dismissed.
Lordship.
I was there for the state. Actually, it was to damages, it was connected to damages, because when the line goes over the land, the below the line, some damages were caused. That was the case. 36 cases were. It was dismissed.
All the cases.
All the cases.
What is the order? We'll see.
There, my lord, I can give the number now.
Next occasion, I will submit the order. Lordship.
Yes, that would be.
Next occasion.
1/6, my lord, 11. Because it will help my lord to decide the case. The parties had in the district court, the reference court, had asked for something like 68 lakhs, 69 lakhs. They were only given something like 3 lakhs, 2.5 lakhs, something like that. So the quantum of increase is not that much as it was projected. So ultimately, the High Court upheld that order. that the increase is not that much. They had asked for 68, 69 lakh. They got only 3.5 lakh something like that. So what, that is not unreasonable.
What is the order will say?
Lords,
Published.
may I please, your lordship. The petitioner before lordship is a tenant. Petitioner before is a landlord tenant, it's a eviction sheet, your lordship. The eviction sheet of the respondent, your lordship plaintiff, is dismissed by the learned trial court. After that, they have filed a preparatory appeal, and the learned civil judge senior division set aside the order of the trial court, passed the order against the judgment against the petition. Your lordship, I have filed this petition on 2 grounds, your lordship. The due date of payment was not fixed, your lordship. Without proving the due date, learned trial court has passed the appellate court has passed the impugned judgment. And moreover, there is a exhibit 2, house rent account book, self-appointed, the self-maintained. It was maintained by the respondent's plaintiff's wife. The author of the documents is not proved well, not examined. But the learned appellate court has relied upon that document and passed the judgment decree. Author was not able, merely exhibited documents without proof the author, it cannot be relied on. And moreover, the learned, the petitioner, due to unhealthy atmosphere, he's deposited the rent since January 2018, he's depositing in the court, your lordship. But that control board under the provision, your lordship, but it is not considered. It's the case. And reason, your lordship, learned trial court decision, page 38, your lordship, not your lordship. Trial court, page 38 onwards, trial court judgment, yes.
Okay, at this, it says, let notice go, let record come, we will hear it.
In that stay may be recorded, eviction suite, stay recorded.
Pardon?
Stay of the judgment is recorded, eviction suite, your lordship.
So whether they have started execution process?
No, your lordship, no, not yet.
So when they start the execution proceeding, then only we see. At this, it says, let notice go. Heard Mr. Islam, learned counsel for the petitioner. This petition under section 115 of the Code of Civil Procedure, read with Article 227 of the Constitution of India, is directed against the judgment and decree dated 7/1/2025, passed by the learned civil judge senior division Tinsukia, entitled appeal number 6 of 2024. It is to be noted here that by the impugned judgment and decree dated so and so, the learned civil judge senior division Tinsukia has allowed the appeal by setting aside the judgment and decree dated 7/5/2024, passed by the learned civil judge junior division Tinsukia, entitled sub number 46 of 2007. Whereas the petition and the documents placed on record, and also whereas the impugned judgment and award, the judgment and or decree dated 7/1/2025, passed by the learned civil judge senior division Tinsukia, entitled appeal number 6 of 2024, and also perused the judgment and decree dated 7/5/2024, passed by the learned civil judge junior division Tinsukia, entitled suit number 76 of 2017. Let notice be issued to the respondents. Respondent returnable in 4 weeks. Step be taken by registered post with AD and also by usual process within a week from today. Registrar shall call for the record from the learned courts below. List the matter after 4 weeks. Interim period of the petitioner will be considered on next returnable date. List after 4 weeks.
Item number 7.
My lord. This application is directed against the order dated 21/12/2024, passed by the learned civil judge junior division number 4, entitled suit number 560/2021. The facts of the case is that I am the tenant of the respondent number 1 and filed on title suit for protection of my illegal eviction, and against which they have filed a WS and a counterclaim. And in respect of the counterclaim, I filed one my written statement. And during the trial proceeding, I called for the NJ cases which I have filed in respect of the suit premises for deposit of the rent. And that application was earlier allowed, but on account of non-taking of the steps, that was calling of the records was barred. Thereafter, I filed one application under Order 7, Rule 14, with copies of the NJ cases, certified copies of the NJ cases, and seek the permission of the learned trial court below to permit the petitioner to allow him to adduce those certified copies in the evidence of the petitioner. And by order dated 21/12, 2024, the same was dismissed.
Mr. Moore, you see the calling of NJ cases, case records
Yes.
were barred by order dated 4/4/2024. That order is not under challenge.
No, my lord, I'm not challenged because due to my fault. My junior colleagues have not taken steps. That's why that
You
was
Mr. Moore, you show me how this order is arbitrary and illegal.
my lord. Order 7, Rule 14. What speaks that, Your Honor? My lord.
No, earlier you have been given opportunity
Yes,
to
yes,
call
my
for
lord.
the records,
Yes, my lord.
but you have failed to avail the same.
My lord.
Then there is no explanation also.
I have explained that is. That's I have
Where?
explained in my application also. I explained.
Where is the application?
Application is at page 100.
Hundred.
Yes, madam. That the plaintiff earlier filed one para 2. The plaintiff earlier filed one petition number such and such dated in for calling of the Ms. J case records, and same was earlier allowed, and thereafter the
Page number 100 is annexure 6. It
sorry, my lord.
is an objection filed by the opposite.
No, it's my lord, and page number 95. Sir.
Yes.
That the plaintiff earlier filed one petition number such and such dated for calling of the following Ms. J cases records, and same was earlier allowed, and thereafter this owner was pleased to close the calling of the Ms. J case records. That on account of closure of the pair 3, that on account of the closure of the calling of Ms. J case records, the plaintiff had applied certified copies of the aforesaid Ms. case such and such, and received certain records, and some were yet to be received at that time. Now I have received all them. The penalty is
Okay.
he may be
let-
permitted to
Mr.
exhibit.
Moore, at this it says let notice go to the respondent.
Right.
Heard Mr. Moore, R.K. Moore, learned counsel for the petitioner. This petition under Article 227 of the Constitution of India referred against the order dated 21/12/2024, passed by the learned civil judge junior division number 4, Kamrup M. Guwahati, entitled suit number 560 of 2021. It is to be noted here that by aforementioned order, the learned trial court has rejected the petition filed by the petitioner to submit the certified copies of Ms. NJ case records as read by the petitioner by petition number 873 from 2024 dated 3/8/2024. Peruse the petition and the documents placed on record, and also peruse the order dated 21/12/2024 passed by the learned trial court. Let notice be issued to the respondent. returnable in 4 weeks, the be taken by respect post with AD and also by equal process within a week. List after 4 weeks. That what is this? The case is pending.
Evidence is taken.
Evidence.
Till returnable, it may
Stay.
still.
Let the other side. Higher.
Item 8. May I please, Your Lordship? So this is an application under Article 227, my lord. We are challenging the order dated 24/7/2023 passed by the learned MSCT Nagaon in Miss case number 16 of 2023 on the ground that learned tribunal has passed the order without jurisdiction. So in brief, my lord, the claimant in this MSC case, my lord, he sustained injury in a motor vehicle accident on 4/7/2022. And the corresponding PS case was registered thereafter, my lord, and he filed a claim petition on 8/2/2023, my lord. Now, my lord, by the amending Act of 2019, the provision of 166 subsection 3 of the MP Act has been amended. It is effective from 1/4/2022. And subsection 3 of section 166 says, my lord, no application for compensation shall be entertained unless it is made within 6 months of occurrence of the accident, my lord. The accident took place on 4/7/2022. He ought to have been filed a petition on or before, my lord, 30/12/2022. He filed the application on 8/2/2023. And there is a delay of 32 days.
That's all right. Now, if there is no provision, how can the court condemn the same?
My lord,
If there is no provision in
Yes.
the act itself for condemnation of the delay,
my lord,
how can the court condemn?
that
The
is
delay.
that is under challenge, my lord. That is under challenge. He has acted beyond jurisdiction of the provision of 163, my lord. Now, our coordinate bench and as well as that there is this decision of the Supreme Court in the subject, my lord, that has been stated. The proceeding and the matter is under, my lord, the provision of the Apex Court, my lord. May I place one decision of the coordinate bench, my lord? Ekta ki bole bole. Absolutely on the similar facts, my lord. Order dated 27/3/2024, my lord. Paragraph, your lordship, may paragraph 7, my lord. The learned counsel submitted that the very initiation of the proceeding by order that so and so by condoning the delay was expressly in violation of the provision of section 163 of the Act of 1988, and as such, all further proceeding in respect of to the said proceeding, that is MSC case number so and so, has to interpret with, taking into account that petitioner has made able to make out a prima facie case for which the court stays the further proceeding of MSC case number so and so pending before the learned member so and so, my lord. Now, the present appellant in another proceeding, my lord, before the Tripura High Court, my lord. Same facts, my lord. They have challenged the condemnation of delay, my lord. It was not interpreted, then it travels to Supreme Court, my lord. I am furnishing the copy, my lord, on the same ground, my lord.
Heard Mr. T. Hazul, Lord at Council for Documents. Order dated 24/7/2023, passed in Miss case number 16 of 2023, passed by the learned member Motor Accident Claim Tribunal, Nagaon, is challenged in this petition under Article 227 of the Constitution of India. Mr. Hazurika, learned counsel for the petitioner, submits that MSC case number 193 of 2023 was instituted on 13/2/2023.
No, my lord.
After-
It was instituted on 8/2/2023, my lord. 8/2. Lordship will find at page 14, Annex 1,
Page number?
14. my lord. The claim petition was filed on 8/2/2023. Vertically, my lord, right side.
Was instituted on 8/2/2023, while the accident took place on
4/7/2022,
4/7/2022,
my lord.
4/7/2022, and there was delay of 32 days in filing the claim petition. And there was no provision for continuation of delay in the amended Act of Motor Vehicle Act. And as such, the impugned order of continuation of delay of 32 days by the learned trial court, no, by the tribunal, is contrary to the provision of the Act. And therefore, Mr. Hazurika consented to allow this petition. The submission so advanced by Mr. Hazurika needs further consideration at this stage. Notice be issued to the respondent return agreement for which step be taken by registered post with AD and also by usual process within a week from today. Since the delay of 32 days was confirmed by the learned tribunal in absence of any statutory provision, this court each of the prima facie view that still returnable that the impugned order dated 24/7/2023 has to be stayed, and accordingly the impugned order dated so stands to stay.
My lord,
Please come
the
forward.
proceeding of the MSC case, my lord, that may be stated, my lord.
Pardon?
The proceeding of the MSC, connected MSC case, my lord, MSC case 193 of 2023.
Further proceeding of MSC case number
193 of 2023. 93, my lord.
193 of 2023.
Pending before the MSCT Nagaon, my lord.
Pending before the learned tribunal, MSC. MSCT Nagaon.
Shall be stated. I'm obliged.
Item number 9.
Wait, please, your lordship. The petitioners were the defendants in a suit, your lordship. Initially, there was an amendment that was allowed, amendment of the plaint that was allowed in 2017. Thereafter, the suit proceeded. After the cross-examination of the DWs, the plaintiffs once again prayed for an amendment, and page number 33, Annexure 5 is a petition by which they wanted to insert one schedule after the cross-examination of DW.
Mr. Mukherjee, the suit was for partition.
Partition.
And by amendment, another plot of land is incorporated in the schedule of the
Another plot. Our contention is that, your lordship, that plot of land was within very much knowledge of the plaintiff, your lordship, and that was not an ancestral property that we have stated. Not an ancestral property. What they are projecting, that is the plot of land in which the defendants are residing as on date, your lordship. So they wanted to incorporate, that was within their knowledge at the time of institution of the suit. After cross-examination of the DWs, they want to incorporate that property as well. So again, the entire exercise of evidence and everything will have to be done after the DWs, your lordship. That is the difficulty, your lordship. And they have nowhere stated, lordship, Annexure 10, page 50 is the petition by which they wanted this incorporation of this amendment, your lordship. Simply, the sentence is the plaintiff intends to amend the plaint by inserting the following paragraphs. No explanation as to how this is important and as to why they did not incorporate it in the initial plaint, your lordship. Page 50, Annexure 10 is the petition.
Let notice go at it.
Lordship. But the next date is fixed at 19/4, your lordship. If the suit proceeds again, the entire process of evidence and everything will have to be carried on because of this new insertion.
Mr. Mukherjee, there is a recent decision of Supreme Court where it is stated that every amendment shall be.
Lordship, I understand. But the proviso to order 6 rule 17 is also there, your lordship.
So that aspect was also considered by the learned trial court.
Only single line was written, but not explained, your lordship. Even the petition did not state why there was no, it was not incorporated in the initial plaint. Even there was an amendment in 2017.
Okay, let the other side appear, we will see.
Lordship, that interim prayer may be kept open.
Ah, okay. Heard Mr. Mukherjee, learned counsel for the petitioner. This petition under Article 227 of the Constitution of India, read with section 151 of the Code of Civil Procedure, is directed against the order dated 12/12/2024, passed in BJ case number 2 of 2024, arising out of PS number 6 of 2022 by the learned civil judge within Package Junior Division, Disney. This we noted here that by aforementioned order, by the impugn order, the learned trial court has allowed the amendment petition filed by the plaintiff for amendment of the plaintiff. Mr. Mukherjee, learned counsel for the petitioner, submits that the amendment was allowed after commencement of the trial, and no reason was assigned for delayed filing of the aforementioned petition for amendment. And without considering the same, the learned trial court has allowed the amendment petition. And therefore, Mr. Mukherjee submits that till returnable date, further proceeding of the title suit number 6 of 2022 pending before the Court of Learned Civil Judge Junior Division, Disney, may be stayed. Let notice be issued to the respondent, returnable in 4 weeks. They be taken by registered post with AD and also by usual process. List after 4 weeks, interim pair will be considered on appearance of the other side.
Item number 10.
May it please your lordship. My lord, the order assailed in the revision petition, that page 42, my lord, by which, my lord, my prayer for adjournment to adduce DW was rejected and DW was closed. DW in respect of DW2. Now, my lord, just in nutshell, my lord, the respondent herein filed suit for recovery of an amount of 65 odd lakhs, which was paid in advance to the petitioners herein for a sale transaction, alleging that the sale transaction could not be completed in time. The respondent being the petitioners herein being the defendants in the suit filed written statement cum counterclaim, in which they contended that apart from the agreement for sale, there was also an execution of memorandum of understanding, by which the defendants in the suit were allowed by the plaintiff to carry out with development works in that land, in the scheduled land. And accordingly, they carried out developmental works and incurred an expense of 1 crore 50 lakhs. Now, the counterclaim has been filed for recovery of the balance amount apart from the amount paid by the plaintiff. Now, insofar as that expenditure is concerned, my lord, that was assessed by a civil engineer. The estimate of the cost, the expense that was incurred, that
No,
has been,
Mr. Chakraborty, come to the point.
my lord,
Come to the impugn order.
my lord, now what has happened, the DW2 being a civil engineer was supposed to be examined as DW2. 2 dates, my lord, adjournment was sought for because he had preoccupied, my lord, assignments for which he could not appear before the court. On the third day, the reason that was cited in the petition, my lord, the petition has been annexed, wherein it was stated that he had to leave for Shillong for some official work and for which one date was prayed for. Now, on that date, the petition was rejected by the impugned order, which your lordship will find at page 43 onwards, my lord. This is the type copy, my lord, your lordship will find at page 42, order dated 24/2/2025. Both sides represented, defendant side filed a white petition number so-and-so, sought adjournment stating that evidence in chief of other DWs could not be filed as DW2 left for Shillong. Perusal of case record shows that since 24/10/2024, the defendant side is taking time. However, the ground today has not been sufficiently explained, hence the petition is rejected. DW closed, fixed 21/3/2025 for arguments. On 21/3/2025, the court was not functional. Now the matter is fixed for argument on 8/4. Now, my humble contention, my lord, is that even the provision of order 17, rule 1 itself, there is a scope for, my lord, allowing adjournment for 3 occasions. For more than 3 occasions, if it is for more than 3 occasions, then of course, my lord, there is a restriction. But if your lordship kindly takes up order 7 rule 1 for a while, the intent of the legislation itself provides, my lord, your lordship, I'll just read out order 7 rule 1 for a while.
Order?
Order 17. Order 17 rule 1, my lord. May I read, my lord? Court may grant time and adjourn hearing. The court may, if sufficient cause is shown at any stage of the suit, grant time to the parties or to any of them, and may from time to time adjourn the hearing of the suit for reasons to be recorded in writing, provided that no such adjournment shall be granted more than 3 times to a party during hearing of the suits. Now, here in this case, my lord, your lordship will kindly see there were 2 occasions. One on 24/10/2024, when the matter was fixed for DW for the first time. On 24/10/2024, the first adjournment was sought for at page 35. That was allowed. Then for the second time, my lord, the prayer was made at page 36. That is on 19/11/2024. That was allowed. Now, on 24/1/2025, the court was not functional. And then on the very third date, that is on 24/2/2025, the prayer was rejected and DW was closed. And here, my lord, the petition, my lord, that was filed seeking adjournment for one more date, that was not even under objection. The other side did not raise any objection to that also. In the petition, my lord, we have categorically taken the ground, my lord, that the DW2, who is a civil engineer, he is not an interested party. He is the one who has assessed the expense that was incurred by us in carrying out the developmental works pursuant to the MOU.
No, Mr. Chakraborty, you say
My
on 24/10/2024, you have filed one petition.
Yes. That,
And thereafter,
yes. On
on
19/11.
19/11/2024, you
One.
have filed another petition.
Another petition, man. These were the 2 dates on which adjournments were sought. On 24/1/2025, the court was not functional. The learned PO was on earned leave, that your lordship will find at page 38. Now, thereafter, the matter was fixed on 24/2/2025. That was the third date. On which the court was functional, but unfortunately, the DW2 had to leave for Shillong. So we filed a petition. The petition, your lordship will find at page 40. So we took the ground that the DW2 had to leave for Shillong, but otherwise the evidence in chief was ready, my lord.
No, the cases takes for evidence of DW
Yes, my lord.
prior to 24/10/24 also.
Yes, that was done prior to 24/10/2024.
But you have not enclosed those orders it's yet.
No, we, my lord, from
Unless you produce those order sheet, how can we ascertain that you have not availed adjournment for more than 3 occasions?
No, your lordship will kindly see from the order impugned itself. If your lordship kindly sees the order dated 24/2/2025, your lordship will see that the learned court below has taken note of the adjournments which were being taken from 24/10/2024. Lordship kindly sees page 42 for a while, because DW2, DW1 was examined prior to that. Prior to DW2, DW1 was examined. DW1's my lord, cross-examination ended. I have my lord,
No,
mentioned the date.
Mr. Chakraborty,
My lord.
going by the rule 1 of order 17, can it be said that for each of the witnesses, you were supposed to examine, the court has to grant the adjournment?
Basically, my lord, order 17 rule 1 is for giving, my lord, the provision is enabling the party adjournment, but it cannot be more than on 3 occasions. Now, adjournment was not sought for on earlier occasions.
We will consider your pair, you produce the
Order sheet of
order
the
sheet
previous.
prior to 24/10/24.
My lord, in that case, my prayer would be, since the matter is again fixed on 8/4 for argument.
No, prior to that, we will
My
list the
my lord, I'll produce the certified copy of the order sheet of the previous.
from who is that this DW evidence for DW?
My lord, I'll just specify, my lord, this list of dates, if your lordship kindly sees. Here I have categorically mentioned on 21/9/2024, DW1 was cross-examined. In my list of dates, I have categorically mentioned on 21/9/2024, DW1 was cross-examined. Then thereafter, the matter was fixed for further DWs. Now, the very next date after 21/9/2024 was 24/10/2024. Now, the adjournment that was sought for was on 3 occasions, my lord. 24/10, 19/11.
That's all right. From the date of fixing the case for DW.
Further
you
DW.
produce, not further DW,
For
from the very
DW.
beginning of the DW.
My lord, my lord.
Third, Mr. Chakraborty, learned counsel for the petitioner. Place this matter on COVID.
First week of April,
Before 8th April.
4th April.
4th April.
So as to enable Mr. Chakraborty to produce the order sheets of the learned trial court from the date of fixing the case for DW.
My lord, the certified copies I'll produce.
Certified.
Item number 11.
My lord, in item number 11, we have filed an injunction petition in the suit that was filed by us. And in the injunction petition, my lord, we paid for an ad interim protection of injunction. That your lordship will kindly find at page 122, the injunction petition starts.
Before which court?
Before the court of the learned, civil judge, senior division, to Kachar Silchar. And miss case 65 of 2025 arising out of title suit 39 of 2025.
So this revision petition is against the order of rejection of?
No, it is actually not of rejection, my lord. Page 139 is the impugn order, where our prayer for ad interim injunction has not been considered. Notice has been issued and it has been observed that it is a fit case where.
Now, Mr. Chakraborty, you tell me whether appeal will lie
No.
or revision will lie.
No, my lord. Appeal will not lie. Order 43 Rule 1R of the Code of Civil Procedure actually provides for appeal in case of either grant or rejection of injunction order under Order 39 Rule 1 and 2. But when it comes to ad interim injunction under Order 39 Rule 3, Order 43 Rule 1R is silent. Your lordship kindly takes up Order 43 Rule 1R for a while. Your Lordship kindly sees at order 43 Rule 1R, the appeal is in respect of an order under Rule 1, Rule 2, Rule 2A, and Rule 4 of Rule 10 of Order 39. Here, Order 39 Rule 3 is not envisaged in this appellate provision, my lord, under Order 43. Now, I had to come under supervisory jurisdiction of this honorable court under 227 of the Constitution of India. Now, my only contention here is that we had in our injunction petition sought for an ad interim injunction on the categorical ground that we have been dispossessed by application of force. And now there is an attempt by the respondents herein to change the nature, feature, and character of the suitland, and also an attempt to alienate the suitland. Now, notice has been issued, my lord. The matter has been fixed on 11/4/2024 before the learned court below for showing cause and filing objection in the injunction petition. If, my lord, till then the status quo is not directed to be maintained, and if the nature, feature, and character of the suitland is changed, our injunction petition and even the suit, my lord, will be rendered infructuous. So my humble contention is that at least, my lord, till 11/4/2025, on which date this injunction matter is fixed, I'm not even asking for any stay of the proceeding or, my lord, stay of the injunction petition. At least status quo in respect of the suit line, my lord, may be directed. Otherwise, my suit and injunction petition will be rendered infructuous. My prayer, my lord, your lordship will kindly see. At page 20, my lord, of my petition, my lord, I have made the prayer, and I've, my lord, sought for an interim prayer to the extent of, my lord, status quo in respect of the suitland. Because on 11/4, my lord, the matter is fixed for objection. And if the other side, my lord, comes to know about the filing of the suit as well as the injunction petition, without there being any legal restriction imposed upon them by the learned court below in regard to the suitland, they will carry out their rampant activities to the extent of changing the nature, feature, and character of the suitland, and may even alienate the suitland. So then, my lord, the difficulty would be a third party right will get created. Then, my lord, there would be, my lord, a situation where, my lord, it may lead to multiplicity of proceeding. So that's why my humble contention is ad interim injunction, my lord, ought to have been considered here.
What is the impugn order?
Impugn order, your lordship will find at page 139. My lord has got 139. Registered the petition number so filed by plaintiff petition under section 94 read with order 39 rule 1 and 2 with section 151 CPC and proviso to rule 3 of order 39 CPC as Ms. J case, petitioner is represented. Heard the learned counsel for the petitioner. On perusal of the case record, I am of the considered view that it would be fit and proper to hear the other side before passing an effective order of injunction in the present case. Issue notice on the opposite parties to show cause as to why the injunction is as prayed for by the petitioner should not be granted to him. Petitioner to take steps. Fix 11/4/2025 for show cause. Now, your lordship, if your lordship kindly takes up order 39 rule 3 for a while, my lord. My lord, order 39 rule 3. Before granting injunction, court to direct notice to opposite party. The court shall in all cases, except where it appears that the object of granting the petition would be defeated by delay, before granting an injunction, direct notice of the application for the same to be given to the opposite party, provided that where it is proposed to grant an injunction without giving notice of application to the opposite party, the court shall record the reasons for its opinion that the object of granting the injunction would be defeated by delay and require the applicant thereafter the formalities, my lord. So we would have been, my lord, prepared to, my lord, comply with the formalities, that is serving of the notice within 24 hours by way of an affidavit and the formality. But our ad interim prayer, my lord, for injunction was not considered at the very first day of passing the issuing the notice,
No,
my lord.
your petition was not only under proviso to Rule 3. It is also under Rule 1 and 2.
1 and 2 is, that is for temporary injunction. That is the routine, my lord, injunction petition that we filed. But apart from that, we expressed our urgency in our injunction petition itself. My lord, we have expressed our urgency for grant of ad interim injunction, and we have narrated the entire, my lord.
But Mr. Chakraborty,
My lord.
I have seen only the appeal filed by the parties against refusal to grant ad interim injunction.
Beg your pardon, lordship.
I have seen only appeal filed by the parties for refusal to grant this ad interim.
My lord, that is what I, my lord, have just pointed out before your lordship. In so far as the appellate provision is concerned, that is under Order 43, Rule 1R. Against injunction, my lord, either for grant or for rejection, the appellate provision is under Order 43, Rule 1R. Now, your lordship has seen in Order 43, Rule 1R, there is no provision for appeal against an order either of grant or rejection of an ad interim injunction, which is under Order 39, Rule 3. So once the very specific provision is missing, my lord, I am, my lord, handicapped in so far as coming in an appeal is concerned. My lord, your lordship is correct to the extent that there might have been appeals filed against such order. But here, specific provision of law, my lord, restricts me from coming up in appeal because the appellate provision itself is not there. It is only in respect of Order 39, Rule 1 and 2. When either a temporary injunction is granted or rejected.
Can you show me any authority on this one?
My lord, authority, my lord, that of course I'll have to, my lord, check out on. One, my lord, of
let
course,
it be on
Surya
Monday
Dev Rai, my lord, is on a different footing. Surya Dev Rai is on a different footing. Surya Dev Rai, the Honorable Apex Court ruling on Surya Dev Rai, that is in respect of, my lord, the scope of a revision petition under Article 227. But on this very specific point, my lord, the law itself, my lord, does not allow me to final appeal.
Okay, we'll list it on then next Wednesday.
My lord.
You come here.
My lord.
We'll see.
My lord. My lord.
Heard Mr. Chakraborty, learned counsel for the petitioner. This petition under Article 227 of the Constitution of India is directed against the order dated 3/2025 passed by the learned civil judge senior division number 2 Kasar Silchar in Ninja case number 65 of 2025 arising out of title suit number 39 at 2025. This will be noted here that by the aforementioned order, by the impugn order dated so the learned trial court has simply issued notice in the injunction petition without granting an interim injunction as applied for. Mr. Chakraborty, learned counsel for the petitioner, submits that against the impugn order, only revision petition will lie, not an appeal as provided under Order 43, Rule R.
Rule 1R.
1R. Place this matter on Wednesday next.
2nd April.
My lord, can this matter also be on 4th? Both these matters.
Okay. So as to enable Mr. Chakraborty to satisfy this court that this revision petition will under Article 227 of the Constitution. Instead of appeal.
Obliged. Obliged.
Item number 12.
May I please, Your Lordship? My lord, in this case, the petitioner is the plaintiff. He filed a suit for ejectment of the defendant, and the suit was decreed ex parte. Thereafter, execution proceeding was initiated. In the execution proceeding, the defendant opposite respondent, they appeared and filed a petition under Order 9 Rule 13. In the said petition, the petitioner side examined 3 witnesses, my lord. On the last witnesses, my lord, that is the PW3 at page 52. This is the evidence of PW3, that is the dependent petitioner who is a tenant under me. As per my knowledge, the area of AC Dasgupta Road is locality now. But 2016, the office of present is less reasonable. In 2016, east side of the road was given address to Mozadar office, in the west given address. I did not go to the Mozadar office and ask the defendants whereabout. In my report, I have submitted the and this is the in cross-examination part you will also can see below that. On 3/10/2016, I visited the mentioned locality of the summons as per the address. I did not write in my report that I did not find the addressee. Further cross-examination dispensed with by the how the court can dispense with the further cross-examination. And my lord, the next which is impugn order, you will kindly not see. Both sides are represented. That is on the same day, 7/3/2025. Today is the fixed for evidence of the processor. Process servers, namely Saiful and Abhijit, are present. Petitioner first examines Saiful Islam, thereafter counsel of the opposite party examines Saiful Islam, but during the cross-examination, the learned counsel attempted to put before the process server the specific question about the events of the day when he had gone to serve the summons of the knowledge will only with the process server, or will it be in the report. But on the other hand, the counsel cannot put any question about the facts which are mentioned in the report. Therefore, the court restricted the question to put the counsel for the opposite party. Accordingly, the opposite party cross-examination of the process server was discharged. Thereafter, the process server Abhijit Sarkar was examined, but during the cross-examination, the engaged counsel of the opposite parties asking the questions about the authenticity of the report and tried to force him to give the answer which suited in his line of questions. Therefore, it appears that the engaged counsel of the opposite party, having some doubt in report of the process server, the counsel also argued that the court asks to stop the facing to responsive process server. Therefore, since the learned counsel himself doubt the report of the process server, it is considered opinion of the court that he agrees to some extent that the petitioner that there are some irregularities in the report, and thereafter I deem it proper to stop the cross-examination as the decorum of the court was not maintained also. And also I do not see any purpose for further cross-examination. Considering the stance of engaged counsel, it is to disbelieve that the report of the process server. I deem it proper to direct to fix the matter from the evidence of the process server today. I gathered the fair information about the case of the woods.
How you are agreed by this order?
My agreement order because I was not allowed to cross-examine. Page 53. On page 53, your lordship can see. Cross-examination part.
3/10/2016, I had visited the mentioned locality of the summon of the address. I did not write in my report that I did not find the address. Further cross-examination is dispensed. How?
Hmm.
Without completing the cross-examination, how the learned Munsif can dispense with the my right to cross-examine the witnesses? My submission is this order is upon,
Learned trial court has only dispensed with.
yeah, dispense it means I am debarred from cross-examine. Dispense with the cross-examination, the evidence in C will remain. My lord, the order of the Munsif is apparently illegal.
Hmm.
And my lord, the learned Munsif has not exercised her judicial mind, my lord. It appears from the order sheet that she is arrogant. So far, the other side advocate or our advocate is concerned. Therefore, she has dispensed with the cross-examination. The Munsif has never exercised her judicial mind. This is not the order to be passed. Further cross-examination is dispensed with. And I have not found that such type of order, madam. Yeah, my submission is this: your lordship can set aside this order, impugned order, and direct the Munsif to complete the cross-examination. And the other side will not be prejudiced. Because on the other side, objection, this order was not passed. It is the Munsif who has passed the order. It appears that she is predetermined to give some relief to the petitioner.
No, that kind of inference cannot be drawn at this stage. No, going by this impugned order, can it be said that because Lord Munsif has never arrived at any conclusion, it is fixed for order only.
No, my lord. My cross-examination is not complete. My cross-examination, the learned Munsif cannot dispense it.
Okay. Heard Mr. S.C. Sharma, learned senior counsel, assisted by Mr. G. Bhagwan, learned counsel for the petitioner. This petition under Article 227 of the Constitution of India. The petitioner has challenged the correctness or otherwise of the order dated
Order dated 7/3/25.
7th of March 2025, passed by the learned civil judge junior division number 1. Dhuburi in Mizje case number 36 of 2023, arising out of title execution case number 1 of 2021. Mr. Sharma, learned senior counsel for the petitioner, submits that the petitioner as plaintiff has instituted suit against the respondent for a decree of declaration, a decree declaring eviction and recovery of rent. And in the said suit, the respondent herein did not contest the suit. No, the respondent herein did not contest the said suit, and as such, the suit proceed ex parte. Thereafter, the learned trial court decreed the suit. And thereafter, the petitioner has put the decree into execution, wherein the respondent filed on petition for setting aside the ex parte decree for non-service of summon. The petitioner herein filed objection. Thereafter, the respondent to establish his case filed evidence on affidavit of himself as PW1 and also of the process server as PW2 and PW3. And examined the process server as PW2 and PW3. But the learned trial court during cross-examination of PW3 dispensed with the further cross-examination. And fixed the matter for order. Mr. Sharma further submits that the said order is illegal in as much as the learned trial court has not learned trial court would not to have fixed the matter for order without completion of the evidence of both the parties. And as such, the impugned order, according to Mr. Sharma, is illegal and arbitrary, and therefore Mr. Sharma contented to set it aside and direct the to direct the learned trial court to first complete the cross-examination of PW3. PW3?
Yes.
PW3. And thereafter to pass necessary order in accordance with law. Having heard the submission of Mr. Sharma, learned counsel for the petitioner, I have carefully gone to the petition and the documents placed on record and also perused the impugned order dated 7/3/2025 and also the cross-examination of PW3. Then it appears from the deposition of PW3, which is enclosed with the petition as Annexure 8 at page number 52, that the learned trial court, after allowing the counsel for the petitioner to put two questions in the cross-examination, dispense with further cross-examination. And it also appears from the order dated 7/3/2025 that thereafter the learned trial court has fixed the matter on 26/3/2025 for order. So what happened on 26?
My lord, the trial court, the executing court is under the order of transfer. She has not passed any order.
Okay. Mr. Sharma further submits that though the learned trial court has fixed the matter on 26/3/2025, yet on that day, the learned trial court has not passed any order as the trial, as the learned presiding judge is under order of transfer. Taking note of the submission of Mr. Sharma, learned counsel for the petitioner, and also considering the facts and circumstances on the record, I find sufficient merit in this petition. The learned trial court would not to have fixed the matter for order without cross-examination, without allowing the petitioner to cross-examine, complete the cross-examination of PW3. And as such, the impugned order dated so and so appears to be arbitrary and illegal, and therefore the same is interfered. The impugned order is accordingly set aside and thus the learned trial court is directed to allow the petitioner to complete the examination of suitability and thereafter proceed to hear the matter in accordance with law. In terms of the CRP is dispose of additional on the state itself.
Right. Item number 13.
May I, Lordship. Lordship, before I start, I'd like to set out the brevity of the case, Lordship. So, Lordship, here in this case, Lordship, the petitioner land was acquired in the year of 2001 by the Water Resource Department. The land measuring, Lordship, 4 biga, 15 lakhs, Lordship. So, Lordship, thereafter, Lordship, as per the provision, Lordship, the petitioner amount has not been disbursed by the department, Lordship. So, since last long time, Lordship.
So, Mr. Das, you are against this 3-line order.
Yes, Lordship. Yes, Lordship. So, Lordship, the 24 years matter has been pending, Lordship.
24
years, Lordship. The principal amount has received in the year of 2023, Lordship. So, interest portion has not been received, Lordship. I am playing for the only the interest portion, Lordship. Interest portion, Lordship, against the principal amount, Lordship. It's a stated law, Lordship. So, Lordship, kindly see, Lordship, the order dated, Lordship, Annexure 1, Lordship, piece 24, Lordship. So, here clear defined, Lordship, this honorable court has intervened with it. Lordship, the court is directed file a reference case before the district court. So, I have filed a reference case before the district court.
That's all right.
So, here challenge.
Here only adjournment was granted by the district judge.
Yes, Lordship. Yes, Lordship. But already 90 days over, Lordship. So, they have not filed any kind of the objection against this my petition.
90 days over.
Yes, Lordship. Not a single written instrument has filed, any objection has filed by the respondent authority, Lordship. So, even though, Lordship, the petitioner is
No,
about the
whether this 90 days is inflexible
Lordship,
or flexible.
Lordship,
Can it be extended?
Lordship, my grievance is, Lordship. So, the petitioner is about the 76 years old, Lordship. Ailment situation.
No,
Lordship.
that's all right.
And
First,
even though, Lordship,
you were challenging this order. You saw how this order is arbitrary and illegal.
Lordship, the concern is, Lordship, so the respondent authority, they did not file any kind of the objection, Lordship. Over already exceeded the 90 days, Lordship. So my grievance is, Lordship, the petitioner is it about the 76 years old, Lordship. And even though the vagrant and vagabond situation since last more than the 22 years, Lordship. So whole property has occupied by the department, Lordship, in regarding this flat control, Lordship. So on that basis, Lordship, the 76 years old person, Lordship, so delay
So
has been
merely
going.
because he is 76 years old, no adjournment should be
Lordship, my
granted to
prayer
the respondent. Is it your submission?
Lordship, my prayer is, Lordship, so the matter has been delayed, Lordship. So if the interference in this regard, Lordship, call for record and the issue notice to the all respondents, Lordship.
No, no.
Because
Why
the
should we call for record?
Lordship, kindly interference in this regard, Lordship, because, Lordship, the more than the 24 years has been pending matter, Lordship. So the in the year 2001, my land has acquired by the concerned department, Lordship. And the principal amount received in the year 2023, Lordship. And thereafter, the interest portion has not been recovered, Lordship. And the stated law, Lordship, the clearly defined, Lordship, the section 64 of the New Fair Act, Lordship. And a lot of judgment also, Lordship. One of the judgment, Lordship, the latest judgment, corporate judgment, Manohar Lal case, Lordship.
No. We are not concerned with those judgments.
So, Lordship, the interest portion is the stated law.
So when you have filed this miss case?
Miss case law, I have filed, Lordship, 4/11/2024, Lordship. Miss the case, LA 1/2024.
4/11/2024.
Yes, Lordship.
So 90 days is over.
Yes, Lordship. So, Lordship, judgment,
Yes.
Lordship.
If Lordship may be pleased to come to page 36, my lord. 36 of the civil division petition.
Yes.
This is the order, my lord, passed by this honorable court in the earlier round of writ petition. Now here lordship will find, my lord, that the petitioner has already received the principal amount amounting to rupees 86,13,601. And he says, my lord, that the said amount is inadequate. So therefore, under that circumstances, the writ petition came to be filed before this honorable court. This honorable court said that, my lord, this honorable court do not have the jurisdiction under 226. So if at all he is aggrieved, he will have to make a reference. By that time, my lord, the limitation has already expired. Nonetheless, my lord, this honorable court was pleased to give him the liberty to file an appropriate application before the, my lord, district commissioner. Thereupon, my lord, the district commissioner was also directed to refer the matter to the appropriate court, reference court, that is the court of learned district judge, my lord, for disposal. Accordingly, next page, if lordship peruses page number 38. Page number 38. This is the petition. This is the petition, my lord, filed by the petitioner before the deputy commissioner, thereby praying for making a reference to the, my lord, reference court. And lordship will kindly mark 2 dates, my lord. The earlier order passed by the writ court, my lord, is dated 28/12/2023. 28/12, that lordship will find at page 36. Page 36. It is 23 part, yes, it is 23. 23/12/2023. Because this is more substantiated, my lord. 23/12. Page 37, lordship will kindly see, my lord. 23/12. Now, after 3 months, my lord, he has filed this petition. So 3 months already he has consumed. Nonetheless, he has filed this petition. It is only on 8/3/2024. Because this petition was filed only on the direction issued by the honorable court. It was not an independent petition per se. Then this petition was referred, my lord, before to the honorable district judge. And the honorable before the honorable district judge, he has filed another petition. That lordship will find at page 46. He is aggrieved by, my lord, the quantum of land acquisition compensation that has been granted to him. Now he has one statutory remedy to make an application, my lord, under section 12. Since admittedly, my lord, this land acquisition proceedings were taken up, my lord, under the provisions of 1964 Act. So under that statute, my lord, the appropriate application has to be filed under the provisions of section 12. Now, this application, without filing that application, he straight away came before his honorable court by filing the writ petition. Now, my lord, he files this second writ petition, my lord, second petition at page 46. And kindly see, my lord, what is there? An application under section 64 so and so for payment of interest. This is an identical petition. Absolutely identical.
So, lordship, the principal amount, I have nothing any aggrieved, lordship. So, I have received the principal amount, but concern is lordship, the interest portion.
Please, please, please. Please let me talk. Please let me talk.
Yes.
Please take it.
Yes.
Then lordship will kindly come to page 54. Page 54 is the first order. So therefore, he files 2 identical petitions for claiming enhancement of the land acquisition compensation. One he files before the district commissioner, which was, my lord, sent in reference to the reference court. On having the upon the reference court, my lord, having admitted the matter and issued notice, he files a second application before the reference court on the same ground. And then this order was passed. My lord, will kindly see for 13/11/2024, page 54. So and so. The petition is admitted. Let notice be issued to respondent number 1 to so cause page 55. Next page. Call for the record. So the petitioner shall take steps for notice to. So, my lord, the next date was fixed on 3rd of January 2025 for appearance of respondents, objection and records. Then, my lord, it was going on a regular process, my lord. It was going on. There is no material irregularity committed by the learned, my lord, reference court. Then, my lord, this petition comes, page 57. It's the 3rd petition. He is so excited that he cannot.
Not excited. Lordship, the concern is the agent about the 76 years old, lordship.
No,
as
no,
per
no,
the
Mr. Das, let him complete.
Yes, yes.
Yes.
So this petition, page 57, and this page 57, Lordship will kindly see down below, first title, an application for early disposal. He or he have already filed 2 applications taking interest, and while the reference code down below was just proceeding to decide the matter, thereby asking the other side to file objection, call for the record, he can't even wait for that time. He files this petition. More early, quick. This is the amount of relief appears to be have been claimed by the my lord petitioner out here. Then on this application, my lord, on this application, my lord, this order was passed. The lordship will kindly see, my lord, page 67. Page 67.
This is the imping order, Lordship.
Page 67. Both sides are represented. Learned Council have filed petition so and so seeking adjournment. Petition is allowed so and so for objection. So this order is on the third application, my lord, seeking, my lord, whereby he is paying for early disposal. Whether the matter has to be early disposed or not, to that extent, my lord, the learned reference code below has issued notice. And on the returnable, my lord, on the returnable date, the authorities have taken only one time, my lord. This is the first occasion when the authorities have taken time.
The previous
Now,
order,
now, my lord, if lordship entertains this matter, my lord, and call for the record, who will be benefited, who will be prejudiced? It is the petitioner. The matter will get delayed, my lord. That is how matter, my lord, the state of affairs stands. What more can I submit, my lord? Kindly see.
Lordship, the
What
on
reason?
that-
Mr. Das, better you should withdraw this petition.
Yes.
Otherwise, we are going to dismiss the same.
Lordship, just for a moment, Lordship, with due respect, Lordship. So the department is a part of the negligence, gross negligence, Lordship. So the land acquired in the year 2001, Lordship. So after 22 years, the department has disbursed the principal amount. So
No, that's all right.
as per procedure,
For
Lordship, as
that
per
purpose, you have already filed a petition before the learned district judge. And the matter is sub judice there.
Well, here is a statute law, Lordship, clearly defined, Lordship. The Supreme Court also has, Lordship. The section 80, section 64 is clearly defined, Lordship. The interest portion would be provided by the authority concerned, Lordship. So now 24 years, Lordship. So now the situation is ailment situation of the petitioner, Lordship. The 76 years old, Lordship. So here, Lordship, the page 67, Lordship, they have taken the adjournment, and previous occasion also taken the adjournment, Lordship. They willfully and deliberately taking the adjournment, Lordship. So they're trying to delay the matter, Lordship.
How? What interest they have?
So petitioner
delay
seeking
the
the
matter?
adjournment by the respondent, Lordship.
If we delay the matter, we'll have to pay more interest.
So, Lordship,
More
with
the
due
delay,
respect,
more the interest.
So, Lordship, kindly directed to the learned district judge, Lordship, to expedite dispose of matter, Lordship. So, Lordship, the simple prayer, Lordship. So since a long time has been pending this matter, Lordship. A vagrant situation, Lordship, and since last more than 24 years. So on that basis, Lordship, kindly consider in this regard, Lordship, directed to the learned court below, Lordship, to expedite the disposal of matter, Lordship, within 2 months or 3 months, Lordship, with due respect. On the basis of the 76 years old.
So you have filed this petition on 29/1/2025.
24, 4,
No,
11,
that
20.
you come to this page number 57.
Lordship, this is the Mizze case, Lordship, for early disposal, Lordship. And initial, Lordship, I have filed the Mizze LA case, Lordship, 4/11/2024. This is the reflecting page 45, Lordship. It's a first petition, Lordship. It's a reference case, Lordship. Under section 64, read with 12 and 18, Lordship. The New Fair Act and the Land Acquisition and Requisition Act 1964, Lordship. That petition is 45, Lordship. First petition, Lordship. And dated 4/11/2024. So, Lordship, thereafter they have or respondent authority taken the 2 times adjournment, Lordship. So, on the basis of the Lordship, So the 24 years delay has been matter, Lordship. So
No, that 24 years delay would not come
and
in
even though
this
Lordship,
case.
the 67 years old person, Lordship.
Maybe.
So on that basis, Lordship, kindly consider this legal, Lordship, and directed to the learned court below, Lordship, to expedite this disposition matter, Lordship. And the Lordship, the Supreme Court held, Lordship, that
Unless you can show that the impugn order is illegal or arbitrary, how can we interfere with the same?
Lordship, PS 67, Lordship, and they are seeking the adjournment, Lordship. So they have taken the seeking adjournment. Previous occasion also they have taken adjournment, Lordship. And the previous occasion, Lordship, the PS 66, Lordship, and that day also the respondent authority taken an objection, Lordship. Did not file any objection. So that's why, Lordship, we kindly consider, Lordship, in this regard, Lordship, on the basis of the aged 67 years old citizen, senior citizen, Lordship. And even the Lordship, the vagrant and vagabond situation since last more than 22 years.
How can
Kindly direct, Lordship, simple direction.
you have already received an amount of rupees 86 lakhs 13,601.
And the interest portion calculate, Lordship, I have stated in the para number, Lordship.
How can you claim yourself as vagabond?
The decision power of this court, Lordship.
Pardon?
Honorable Court, if kindly consider on the basis of the age about the 67 years, Lordship. 76 years, Lordship. So, Lordship, here, Lordship, the interest portion, if calculate, Lordship, more than the 3 crores, 3 lakhs, Lordship, yeah, from the date of the 2001, Lordship. And that part I have stated in the para number, Lordship.
Heard Mr. Arcidas, learned counsel for the petitioner, and Mr. Corpusari, learned standing counsel for the respondent number.
1 and 2.
Respondent number 1 and 2, and Madam Fokat for respondent number 3. Respondent number 3. And for rest of the respondent, Madam Bormon, you are for?
Water resource, they have their own standing counsel, my lord. My lord, for respondent number 4, 5, and 6.
So, copy it, sir, Lordship.
In this petition under Article 227 of the Constitution of India, the petitioner has challenged the order dated, challenged the correctness or otherwise of the order dated 1/3/2025, passed by the learned district judge Mangaldoi, Darong Mangaldoi in LA case number 01 of 2024. It is to be noted here that by the impugn order dated so, the learned district judge Dorong Mangaldoi has grant adjournment to the respondent Sherin to file objection. Mr. Das, learned counsel for the petitioner, submits that the land of the petitioner was acquired in the year
2001, Lordship.
2001. And a sum of rupees 86 lakhs 13,601 was sanctioned to him by the respondent authorities. And he received the same on which date you have received the same?
Lordship, 18/12/2023.
18/12/2023. But while calculating the compensation, the respondent authorities have not taken into account the interest which the petitioner is entitled to, for which he has instituted the LA case number
1
of 2024, and also filed one Miss LA case number 1 of 2025. for early disposal of the same, but the learned trial court by impugn order dated but the learned district judge Dorong Mangoloi by impugn order dated 1/3/2025 had granted adjournment by order of granted adjournment to the respondent authorities to file objection. Mr. Das further submits that prior to that date also, the learned trial court, the learned district judge has granted adjournment to the respondent authorities. And that the petitioner hearing is a senior citizen of 67 years old.
76 years old. 76 Lordship.
76 years old. And as such, there is a requirement for early disposal of the petition. And therefore, Mr. Das contented to issue direction to the learned district judge to expedite the matter. On the other hand, Mr. Barpuzari, learned counsel for the respondent number 1 and 2, submits that the impugn order suffers from no infirmity or illegality requiring any interference of this court. And the Miss LA case number 1 of 2024 was instituted by the petitioner pursuant to order of this court in WPC number 4942 of 2021. Dated, what is the date?
Lordship, 1/3/2020.
What?
1/3/2025, Lordship, impugn order.
1/3.
2025.
No, order of this court.
Uh,
In execution.
Yes, that.
9/10/2023, Lordship.
23/12/2023, that lordship will find at page 36.
Uh, 23/12/2023.
My lord.
No, Lordship, the 9/10/2023 most probably is the first order, Lordship. Read petition number 4942, Lordship, page 28, Lordship. Page 28, Lordship. And the relevant parties, Lordship, no, Lordship. Lordship, I'm sorry, Lordship, 35, Lordship. I'm sorry, Lordship. Page 35, Lordship.
Yes, that is.
And relevant parties.
That is what I'm submitting.
I'm sorry. I'm sorry.
23rd, 2023. And though the direction was issued by this court on 23rd/12/2023, the petitioner has instituted the proceeding only on when you have filed it 4/11/2020.
Yes, Lordship.
2024, and thereafter only through adjournment was granted by the learned district judge for the Dorong Mangoloi to the respondent authorities. And as such, Mr. Corpusary submits that this petition is not at all maintainable, and therefore it is contented to dismiss the petition. Dismiss the same. Having heard the submission of learned counsel for both the parties, I have carefully gone through the petition and the documents plus on record, and also produced the impugn order dated 1/3/2025, which is read as under. Both sides represented. Learned counsel for opposite parties have filed petition, white petition number 138 of 2025 and 139 of 2025 seeking adjournment. The petition is allowed. It takes 5/4/2025 for objection. Having examined the impugned order dated 1/3/2025 in the light of the facts and circumstances on the record, and also in the light of the submissions so advanced by learned advocates of both the parties, this court is of the view that no case for interference with the impugned order is made out, and accordingly this petition is dismissed. However, the learned district judge Dorong Mangoldo is requested to expedite the matter and to complete the trial as soon as practicable.
Masabay.
For admission, I don't know according partner meeting.
Last order, Lordship, asked me to get the instruction, my lord.
Hmm.
Allow me some 2 weeks time to get the entire instruction. Instruction has not been furnished. They are searching the records, my lord, but entire instruction I have not received it. my lord.
Heard Mr. Talukdar, learned counsel for the petitioner, and also heard Mr. Hoda, learned standing counsel for the
SCERT, my lord.
respondent number 2 and 5.
2 and 5.
And Mr. Bortuzari for respondent number 3. And Madam for respondent number 4. Respondent number 4. Mr. Bora, learned standing counsel for the respondent number 2 and 5 submits that he may be granted 2 weeks time as the relevant record would not be found out by the respondent authorities. Where is accordingly allowed recessal is the matter after 2 weeks.
That may be fixed and the matter again for part third, Lord.
Okay.
Part third matter.
Place the matter as part heard on
29th, on 28th April. Obliged, Lord.
next.
Sorry, item 19. My lord, kindly for time being, my lord. For time. I am calling new counsel.
Number 20 under order 41 rule to CPC.
Meet please, your lord. Lordship, the connected I is for the prayer for amendment of the appeal memo, lordship. At the time of filing the appeal, lordship, we have not incorporated the substantial questions of law, and it was filed in a separate sheet, lordship. Now the proposed amendment is to incorporate the substantial questions of law in the appeal memo itself, lordship. For this IA has been filed, lord.
This IA?
Lordship.
No, is it necessary to file this IA because the court has already permitted you to amend the memo of appeal?
Lordship.
Side order dated 31/7/2024.
I have misunderstood that, lordship. I will file then, lordship.
Pardon?
I will file then, lordship, in a.
You see,
Lordship.
it is noted that heard Mr. Fukun, learned counsel for the appellant, who praised for some time for filing the amended memo of appeal.
Lordship.
There is allowed. You were already allowed.
Lordship.
Heard Mr. Fukun, learned counsel for the applicant. This interlocutory application is preferred by the applicant for according him permission to file amendment memo of appeal. But it appears from the order dated 31/7/2024 that Mr. Fukun has already been permitted by this court to file memo of appeal. And as such, this interlocutory application is infractious and the same stands closed. Mr. Fukun prays for granting him 1 week time to file amended memo of appeal. There is allowed, recessal is the matter after 1 week.
Lordship. Obliged.
21.
LCR of the title suit has not been received.
Okay. You for the respondent.
Yes, sir.
Non-APS for the appellant on Bhava Mr.
BS Decca.
B.S. Decker, learned counsel for the respondent present. Office note dated 25/3/2025 indicates that LCR has not yet been received from the courts below. Accordingly, it is provided that Vesti shall issue direction to the learned trial court as well as the first appellate court for transmitting the record without further delay. Place the matter after 2 weeks. From
Record
where
of
the record will come.
Title appeal has been received. Lord. Title appeal record has been received. Title suit record has not been received.
No. Office note indicates title appeal. Office note dated 25/3/2025 indicates that LCR of TS number 01 of 2019 from the learned trial court has not been received. This is also a reminder to the learned trial court for transmitting the record without further delay. This is the matter after 2 weeks. From which court it will come? Dhubri.
Lordship.
Dhubri.
22. Item 22.
Please, Your Lordship. My lord, your lordship would be pleased to take the IA 1307 of 2024. 1307 of 2024. Now your lordship would be pleased to see the order dated 23/7/2024.
Yes, Mr. Bhattacharya.
Yes, my lord, the well, dates and certain instructions, but they have not said that they will file affidavit, but certain instructions. That is the 1 lakh something they're asking. That is the calculation, my lord, and that is statutory, my lord. So, and the other objection that I filed, that I had brought to the notice of the court, that I did not file, that I did not object after taking instruction, that I argued from the impugned judgment, my lord. The lower court has come to a finding that the actual land acquisition was done under the 1894 Act, Land Acquisition Act, and not under the act under which he has filed this interlocutory application. That is filed under the 2013 Act. So that is not applicable, my lord. That is the finding of the impugned judgment, my lord. And regarding these things, our officers are not really in the know, my lord, all these things, my lord. These are technical law points. So that was the finding of the impugned judgment of the reference court. So that is from where I objected.
So as per this calculation, he will supposed to get rupees 11 lakhs 14,848.
Yes, that is the deduction was made regarding this, my lord, the judgment is at page 30. Here, I'm reading out the first paragraph. Everything my lord will understand from that only, impugned judgment. The land acquisition has been registered as a referred by Deputy Commissioner Bongaigaon in pursuant to an application of the Land Acquisition Officer, Collector and Deputy Commissioner Bongaigaon under Section 12 of the Assam Land Acquisition Act 1964 and under Section 18 of the Land Acquisition Act 1894 for determination of
Page number,
adequate
you are referring to page number?
30.
No, okay. 30 in the appeal or in the miss case?
In the appeal.
Appeal. Yes, page number 36.
Page 30, 30. The first page of the judgment.
Yes.
The first page, I'm reading again, my lord. The land acquisition case be registered and referred by the Deputy Commissioner Bongaigaon in pursuant to an application of the Land Acquisition Officer, Collector and Deputy Commissioner of Bongaigaon District under Section 12 of the Assam Land Acquisition Act 1964 and under Section 18 of the Land Acquisition Act 1894 for determination of adequate compensation for acquisition land by the petitioner Mohammad Saidur Rahman. So, my lord, that is the finding, my lord, that the land was acquired under Section 18 of the Land Acquisition Act 1894. And this petition, he has, and the money 1,85,000, that is the statutory 5% tax that is taken by the government in every case, man. That has been going on for 150 years. That means whenever a land is acquired, the government has to run the administration, no? For that, some percent of tax is deducted, my lord. And that is explained in that instruction. And regarding the application, my lord, it is clearly written in the first page of the interlegal application number 130 of 2024. It was filed under the 2013 Act, my lord. This is not applicable, man.
So maybe the quoting of section may be wrong, but because of this, you cannot deny their rightful claim.
Yes. My lord, those chart that they have deducted that as they have given
where
a
it is
name there.
mention about deduction of this amount, this tax.
Yes, under Section 12 of the Assam Land Acquisition Act.
No,
It was
no,
under this act.
in the written instruction you have received, where it is mentioned. So, better, Mr. Bhattacharya, you file an affidavit
Yes, ma'am.
based on this written instruction.
On last occasion also, that was the position of the case, my lord. Your lordship directed that affidavit will be filed, showing reflecting the breakup of deduction. Maybe that the instruction may be annexed with this,
Yes, yes.
my lord.
Affidavit in
But affidavit is necessary.
Okay. Heard Mr. MSA, learned counsel for the applicant, and Mr. Bhattacharya, learned standing counsel for the respondent, opposite party. Mr. Bhattacharya submits that he has received written instruction. And he submits that he may be granted some time to bring on record the approved instruction by way of an affidavit, where is accordingly allowed. Raise the matter after 2 weeks.
Yes, ma'am.
So as to enable Mr. Bhattacharya to file affidavit on the basis of written instruction received by him from the respondent authorities.
My lord, may I pray for a date, my lord? Because, my lord, my client is above 90 years old, my lord. So, my lord, there is some urgency. 30, 30, 34.
30 April, yes. 25th.
25th. Okay, much obliged.
Coming item 19, fair hearing matter.
May I please?
City receipt, Lord. Earlier created by this honorable.
City receipt.
Lord.
No, what is the stage of investigation?
Lordship, these absconding lordship and lordship witness or examine and 164 statement also recorded lordship and he is implicated lordship. Sufficient materials against him lordship. And one FSL also.
FSL
FSL report lordship.
receipt.
Receipt lord.
My lord, kindly approve, my lord.
Two I have fixed matter in court number 17.
Okay. Noted to after
After finish.
My lord. Kindly.
23.
Chair, file in one IA for early hearing of this matter. This person is an aged person, so the record is there, already the service is complete. Any date may fix lordship after view vacation.
After view vacation.
After view.
So this IA is filed by the respondent.
Respondent.
Heard Mr. SP Chaudhary, learned counsel for the applicant, and Mr. C. RD, learned counsel for the appellant opposite party. This interlocutory application was referred for early hearing of the RSN number 26 of 2023. Having heard the submission of learned advocate support by party, it is provided that this is the list the matter on.
8th of May or in the in the month of April is not possible.
Already a lot of cases have been fixed in the month of April.
8th of May.
Terms of waiver this IA is not closed.
24.
My lord, the LCR has been received, my lord. Let the matter posted for hearing. my lord.
Ready for hearing?
Yes, my lord.
Okay.
I'm waiting for respondent 1, 2, and 3.
And rest of the, how many respondents are there?
Four, my lord. My lord, already I have informed my lord the trustee service, my lord.
When?
my lord, in IA, my lord. Delay petition, my lord.
That may be in the delay petition, but in the main appeal,
Main appeal, I have, is not directed, my lord.
is it not necessary to serve notice in the main petition, main appeal?
I think it is not necessary, my lord. She is not interested, my lord. She is already married, and her matrimonial house she live, my lord. Yes, 4 is my lord married daughter, my lord.
You are for 1, 2, and 3.
3, my lord.
And 4 is not a necessary party here.
I think, my lord, not necessary party.
So we'll strike up her name.
My lord, may not strike off the name, my lord. Let
Then-
it be, my lord, as like,
Then you represent her?
I cannot. I have not been offered.
You cannot. Then why you are objecting it?
But subsequently, there may be question, my lord.
Okay. There is a office known that notice upon respondent number 4 was served.
Yes, my lord. Deemed to be served, my lord.
Heard Mr. K. Guhai, learned counsel for the appellant, and Mr. Soikia for the respondent number 1, 2, and 3. None appears for the respondent number 4 remain unrepresented today. Mr. Guhai submits that LCR has already been received and the matter is ready for hearing. Accordingly, it is provided that recess shall list the matter for hearing in usual course. It will not be accepted.
No, my lord.
Obliged, my lord.
25.
May I please, your lordship? Lordship, LCR has been received and respondents' service is also completed, your lordship. Their name are being shown, but they are not present today.
This IA is for what purpose?
IA was for stay, your lordship. I was praying for a stay. My first appeal was dismissed, your lordship. My stay may be granted, your lordship. They are not appearing on earlier occasions also. Till the disposal of the appeal, your lordship.
Yeah. Okay, after 2 p.m.
Item 28.
May it please your lordship. Lordship, as per office note dated 11/6/2024, LCR is received and service is complete. They've entered appearance. Sole respondent.
Okay. Heard Miss
S. Kataki, your lordship.
S.
Kataki.
Learned counsel for the appellant and Mr. Deka for respondent, sole respondent. It is submitted at the bar that service completed and LCR has also been received and the matter is ready for hearing. Accordingly, it is provided that recess shall list the matter for hearing in usual course.
Obliged.
29.
May I please, lordship, I file and I'm the appellant, my lord, I is appeal. My lord, kindly see the last order. That accept respondent number 2C. 2C. 2C is the, my lord, the power of attorney holder is the.
So far, 2C is concerned.
Wait, let me.
I'm appearing for that, because I have received the power of attorney.
Acha, you are appearing.
I'm
2C.
The service is complete, my lord.
My presence is maybe recorded.
Matter is ready for hearing. LCR
Not
received.
today is my lord.
LCR received or not?
Received, my lord.
Received.
But this, because they have lost, I'm the plaintiff, my lord. This is a money shoot, 48 lakhs. It is a year 1996.
No, we will hear you.
No, my lord, 50% may be allowed to deposit.
50% maybe?
Yes, a principal amount, 48 lakhs for. He has stably made last 30 years, but this way, that way. Ex parte, again filed, order 9, rule 13, again MFA, again RFA, again remand back.
No, whether any stay was granted by this.
That is not a stay because we filed with the decree holder.
Okay.
Appellant is the decree holder. They have not filed any appeal. So they have not filed, they are not aggrieved. So they have released the amount, my digital amount. Digital amount, my lord. They have not filed any appeal.
If there is no stay, you file
No,
the
stay
execution
means
case then.
I will file an execution case. My lord, I file only the ground of, that is the limited ground that we have 48 lakhs along with that 19.2% interest. The lower court has given the trial court 6% interest. That is for enhancement of the interest.
Only.
Only. That is the value. But this is not a dispute. They have not reduced any evidence because they are ex parte. They have come this court, that court, this court, this court, last 26 years, 30 years. So they file 50% of the ordered amount because it is a money suit, my lord. They have not filed any appeal. They have not agreed.
No. For that you file this execution case before the.
No, although we are reading, but things is that execution case is
Can this
it is not a my lord title suit. It is a suit for money decree, my lord. Money decree, my lord, automatic, like a MECT case.
No.
Like a MECT case, my lord.
It is not like MSCT case.
Because if they agreed, they would have filed the appeal.
Because they are not paying for this staying of the decree, judgment and decree.
That is why. That is why they are not
You
paying
go
for
and file execution case.
we have filed it. The things is
for
that at
the-
this stage.
Mr. Pal, this
My
court
lord, my
cannot
lord.
act as an executing court.
Yes.
You go and
We
avail
have filed in execution because all our respondents are staying at
we are
Calcutta.
fixing the matter for hearing.
Lordship, I submit your lordship. Your lordship, after passing of the degree, and this was an ex parte degree, so we filed an application under order 9/13 before the trial court, and in that case, notice was issued to them. But in the meantime, the court came here, and order 9/13, your lordship knows that that petition is to be disposed of first.
No. My lord, I have a 100%.
I was not disturbing, and now he's.
No. My lord. My appeal, how he has come.
No, Mr. Pal.
Yes.
Let him complete. You please sit down. Please sit down.
My lord.
Lordship, in the trial court, we filed an application under order 9/13 for setting aside the degree since it was past ex parte. And that petition, the notice was issued to them, and a date was fixed. But before that date, the LCR was transferred to this court. The record was transferred to this court. Because of that, our order 9/13 petition could not proceed because the record is here.
So then you file an IA here.
That I have prepared. Yesterday we tried to serve a copy, but he left the court today because the matter is fixed. He could not take the copy. We are filing it today.
My lord, now my lord, kindly see this order of this landed court below. Kindly see. There is here. What is the conduct of the respondent, defendant? Court is elaborately detailed in the order. My lord, kindly see the first page of the LCR, the order. Order is, my lord, kindly go 2/1/24, 5/2/24, and 4/3/24. Well, this is 30 years proceeding the case, my lord. This is my money, my lord. Again, he filed it. They did not fully did not appear. I appear from Guwahati.
Order dated?
My lord, kindly say first page. This is the new case when remand back. This honorable court was remand back for argument. Then it was fixed on 11/12/2023. I was appeared in the Civil Judge Senior Division Nagaon. But they did not appear in the morning. They come in later on, they file an adjournment. Since the record of this honorable court not transmitted, so court has given the privilege to the parties to inform our Peshkar. Peshkar will communicate. As soon as the record will receive by the court, then you will be informed, you will be given time. Then record has received, date was fixed. My lord, they have written order, kindly see first order. Very important. my
Okay, now we will fix the matter for hearing in usual courts.
Not usual, in the month of May, my lord. It is,
No, this is of 2024 matter.
no,
This appeal
but
is of
initially, my lord, 96 matter.
No.
My lord, kindly see that 96 matter. I am suffering my money. Otherwise, I'm not going to say anything more.
Mr. Arshit Pal, learned counsel for the appellant. Mr. PK Jain, learned counsel for the respondent number 1, 2, A,
All the
B,
respondents.
2C, and 2D.
And 3 also we appearing. 2, 3 also we are appearing.
All the respondents.
All the respondents.
For all the respondents. PK Jain for all the respondents.
The
It
first
is
week of month of
submitted
May.
at the bar that that service completed and LCR has also been received and the matter is ready for hearing. Yes, sir, is the matter for hearing in usual court.
No, in the month of May, my lord. But this is.
Lordship,
Okay.
I'm already filing, I'm already filing that petition to my order 9
The
to
liberty
13.
is with you, you can file.
Yes.
My lord. Much okay.
For coming to that, on the present the office not dated 25 respondent service.
Use the microphone.
Lordship, on present of the office note dated 25/5 of 25. 2025. Lordship, service upon respondent has not completed.
Lordship,
I am appearing for respondent 1 and 1 to 4.
actually, we were plenty before the learned trial court. We had final injunction application, and that application was not properly granted, Your Honor, though it was partly allowed. But thing is that, so far the opposite party number 5, 6, and 7 are concerned, we may strike out the case against them, Your Honor, at our risk, Your Honor, because they are the official respondents. Only our grievance is against them only. They are the private respondents.
So
Your
they are necessary parties. Also, Lordship, against the said I.
They have
injunction-
enforced my land, Your Honor.
Against the said injunction, we will file a written objection. We will file
They
an
have,
objection.
Lordship, they have taken time in the
We
last
prefer
year,
some
in the
time.
month of July. Almost 9 months have completed.
On the
Your Honor.
last occasion we had appeared, we pray for some time to file the objections against the said injunction.
No, you see, since 19/6/2024, there is no order.
There is no order, yes, Lordship. But in the month of July, they had appeared, they have committed before this honorable court that they will submit a written objection. So far, the respondent number 1 to 4 are concerned. But till now, Your Honor, till now, they have not furnished the copy.
Are you genuinely interested to file a objection?
Lordship, yes, Lordship. Indeed, Lordship.
Lordship, what 1 week time only may be given, Your Honor. But it's very urgent matter, Your Lordship, because 2 peasants' land has been grabbed by them, Your Honor. 2 peasants' land. They are the Rajan Boro and the Ghanakanta Boro. They are the PT peasants, Your Honor. Very pretty peasants, Your Honor. Small cultivators having 1 bigha, 4 kotha of land only. Out of that, 2 kotha has already been grabbed.
Heard Mr. S.K. Sarma, learned counsel for the applicant. Then Mr. Bhatia for respondent number
1 to 4.
1 to
1 to 4.
So far, the respondent number 5 to 6, 7 are concerned. We desire to strike them now, Your Honor, at our risk, Your Honor.
Okay. Mr. Sarma, learned counsel for the applicant submits that the name of respondent number 5, 6, and 7 may be struck from the array of this application at the cost and risks of the applicant hearing. Taking note of the submission of Mr. Sarma, learned counsel for the applicant, it is provided that the name of respondent number 5, 6, and 7 be struck from the array of this application.
Yes, Lord.
Mr. Bhatia, learned counsel for the respondent number 1, 2, 3, and 4 submits that he may be granted some time to file objection. There is allowed to recess the matter after 1 week.
Only after 1 week, Lordship.
7th of April.
7th of April.
Lordship, can it be on 9 or 27 or a little bit difficulty for us? On
9.
9.
Okay.
Yes, yes, Lord. On 9th. On 9th.
31.
Much obliged.
Page, Lordship.
Yes.
31, I appear on behalf of the sole respondent, Lordship. No, sir.
Who is for the petitioner?
Petitioner is for S. Tipulas Rahman. Nobody appear right now. What happened in this case, Lordship, the respondent have filed a title suit before the district judge Soraido, Lordship, and they have filed the transfer petition for transfer the case from Soraido to Sibsagar. In this case, Lordship, already they have appeared, they have filed it in a statement. PW is also filed, partly cross-examination also have been done. So there is no merit at all in this case, Lordship. Because already they have appeared, they have filed WS, PW also adduced, cross-examination part also done. So here, B letter is that they have come for transfer this case.
No, but in absence of the petitioner,
Yes.
we cannot decide the matter on merit.
After then, Lordship
Can,
may fix any sort date, Lordship.
Yes, on next date, if nobody turn up, then
Then it may be disposed. Any sort date.
then it is
Before
for
Bihu.
the petitioner on call, however, so.
And there is no stay also, Lordship.
Counsel for the respondent number, learned counsel for the respondent present. Oh, stay was not granted.
Not granted till.
Place the matter after 1 week in the event of subsequent non-representation of the respondent. No, for the petitioner, appropriate order shall follow.
Highly available. 32.
Mandatory. The notice was issued on 18/9/2024. And in the meantime, the other side, they have filed objection. But that objection is not on record. So, my lord,
I filed, but it is not, someone received maybe.
You have filed objection, when?
My lord, I filed on 10th of December, my lord, but still it is not in the.
It may be.
Maybe, my lord,
effective,
display somewhere.
maybe, my lord.
So, my lord, the matter may be fixed on 8th of April, my lord, next week, or not next week, 8th of April. Along with that, in the meantime, I will file my.
As agreed by learned advocates of both the parties, the resolution is the matter on 8th of April. In the meantime, the affidavit filed by this respondent shall be placed on record.
Earlier interim order may continue.
Okay, in
Passed on
order passed
18/9.
earlier shall continue.
34.
Please, Your Lordship, delay condonation application. Delay of 25 days in filing the first appeal, Lordship.
Whether notice was issued?
The notice has been issued. In fact, in the cause list, one T. Roy is showing as a respondent counsel. One T. Roy is showing as a respondent counsel. For respondent number 1, 3 and 5, he has filed Wakalat Nawa.
Heard Mr. Bora, learned counsel for the applicant. None appears for the respondent number 1, 2 and
1, 2 and 5.
1, 2 and 5. Do name of one Mr.
Lordship.
No, do one counsel, namely Mr.
Some Roy is there, Lordship.
P. Roy. P. Roy.
P. Roy. P. Roy is reflected in the cause list.
Yes, Lordship.
And in respect of other respondents,
Lordship, in respect of respondent number 3 and 4, 3 and 4 are the daughters of 1. They are minors. So they can be represented by their mother, respondent number 1. So the counsel whose name is showing in the cause list, he can very well represent them.
and for other respondents.
And for other respondents, 6, 7, and 8. Lordship, 6 is the government advocate, senior electrical
Okay.
inspector. Yes.
None appears for the respondent number 6 and 8 also.
6, 7, and 8. Government advocate can appear, Lordship.
6, 7, and 8.
8.
Resolution please the matter after 1 week. In the event of subsequent non-representation of the aforementioned respondent, appropriate order shall follow.
35.
Lordship. In 35, Lordship,
we have, this is a statutory appeal under section 30 of the Employees Compensation Act. We have already deposited the statutory amount which was awarded. And there is a delay of 103 days in filing the appeal. In fact, Dusty service has already been served and we have filed an additional affidavit regarding the Dusty Lordship.
When?
On 4/2/2025, Dusty service was taken and we filed on 11/3/2025. But none has appeared in respect of respondent number 1 and 2, Lordship.
Heard Mr. Bora, learned counsel for the applicant. This application under section 5 of the Limitation Act is deferred for confirmation of delay of 103 days in filing regular parts appeal against the judgment and award dated 28/9/2023 Hospital Learned Commissioner and Employees Compensation Gulaghat in Employees Compensation case number 14 of 2014. Mr. Bora, learned counsel for the applicant submits that the applicant has retracted service of notice upon respondent number
1 and 2, Lordship.
Respondent number 1 and 2. 1 and 2
There are 2 respondents on.
by Dusty Mood and file an affidavit to that effect. And perusal of the affidavit indicates that notice was served upon the respondent number 1 and 2. Respondent number 1 and 2. But despite receipt of notice, they remain unrepresented today. Residents will raise the matter after 1 week. And put up an up-to-date office note indicating whether any council entered appearance for the respondent number 1 and 2. Raise the matter after 1 week.
Lordship.
36.
36, Lordship, there is a delay of Lordship, 103.
Whether notice was served.
Lordship, notice has not been served till date in this case.
Whether you have taken any step. No step taken.
Lordship will take fresh steps and in fact, your Lordship may kindly permit me
Mr.
to.
Bora, learned counsel
Justice
for the applicant submits that he could not take step upon respondent number 1 and 2 and press for granting him some time period is allowed. This is the matter. No, there is allowed step be taken upon respondent number 1 and 2 by registered post with AD and also by usual process within 2 working days from today.
Lordship.
Recessal is the matter after 4 weeks.
Lordship may kindly permit me to take Dusty service, Lordship, in respect of all the respondents.
On the request of Mr. Bora, learned counsel for the applicant, Dusty service is also permitted.
Obliged, much obliged.
May I please, your lordship. My lord, here in this case, I am the respondent. I file an IA, my lord. For early hearing. Why it is
IA?
necessary, my lord? Let me finish first. Page 16, kindly see. Of IA. When the second appeal is pending, by filing a writ petition, obtain an injunction order. Kindly see page 16. In view of the projected made prayer regarding pendency of the second appeal, RSA number so-and-so, with regard to the right title interest in respect of 12 katha of land out of so-and-so, it is provided as an interim measure that there shall not be any disbursement of compensation amount in favor of the private respondent till the returnable date. That means with this, over this land, a Assam Mala has been taken away the land, my lord. And in the suit, my lord, suit was dismissed, first appeal was dismissed, then second appeal. So under such circumstances, I am praying for early hearing, my lord.
I am for the appellant newly engaged on 21/2/2025. I did not receive the copy.
No, he appeared subsequently.
That's why.
Prior to that,
One
I have
copy-
filed this IA. And with
So
third
one
copy to
is
the
required to me.
I have already
Ask
supplied
my
the
learned
copy.
friend to supply a copy. And I also after.
And I am only praying for early hearing, my lord, nothing else. Because of
Respondent
this
number-
order, my lord, because of this order, this case is required to be early heard, my lord.
Response number 16 expired, lordships. I filed necessary application regarding substitution abatement already abated. That is on 28/2/2025.
My lord,
Right.
in this respect, kindly see
Till
page
today not
57.
been listed.
Page
Direction
of the main appeal, my lord. This is also another dilatory text. Kindly see page 57.
person expired. What?
Page 57, kindly main case.
What
my
type of
lord.
submission?
Yes, I am
learned a
showing. I am showing.
Persons expired.
Yes.
Mr.
Yes,
Bhuyan,
yes, lordship. Let him-
Let me finish. Page 57. Lordship got it.
Yes.
Page 53, kindly see. Paragraph 5, page 53. Who expired? The said Hirokjyoti Chakraborty, this Hirokjyoti Chakraborty is expired, is not only the material witness to Exhibit 7, he sold out the land to the defendant number 3 so and so, and plaintiff made him pro forma defendant number 19, but he did not submit any WS and passed ex parte order against him. This Hirokjyoti, now he wants that this Hirokjyoti is to be substituted ex parte before the trial court. Now kindly see the written statement, whether he has contested the case or not. Page 17, kindly see.
No, it is already reflected here.
Yes.
He has not filed a written statement.
Yes. Now he wants that his legal heir is to be substituted. And before this honorable court, that was already, service was complete. Now to delaying the matter, this substitution petition has been filed. That too after 5 years, my lord, of death. 4 years of, after death of 4 years. What necessity for filing substitution?
No, that petition is not before the court today.
Not before the court today. He is saying
Yeah.
that he has filed this petition.
We have
No, if it is not before the court today, you are not
No,
allowed to argue on that point.
No, lordships, here is the impleaded as respondent. It is my duty, lordship, since impleaded
No,
as
that's all right,
respondent.
but that
If not
IA is
contested-
not before this court today.
Today not, but I have filed registry, at
So-
one court, direct my learned. friend
You
to
go and
supply a
inquire
copy.
in the registry.
Yes, lordship, but that.
So that is why I
that
am
may be
filed
recorded.
this application
Since
for.
I have filed by serial number, I have, lordship.
No, you go and check it. Unless
That
this is before
submissions
this
may
court.
be recorded since we have filed, lordship. Registry may direct to list the same.
No.
There is
never,
a,
Never.
there is a lordship filing
No,
number
no.
also.
Heard Mr.
One copy is direct
Learned counsel for
supply
the
to me.
applicant and also heard Mr. Barguya, learned counsel for the respondent. There's a application, interlocutory application is prepared by the respondent. You are for the respondent.
I am for the respondent. Contesting.
Applicant is for respondent.
Yes.
For early hearing of the RSA number 249 of 2017. Where is the petition? And also gone to the record. As the matter is ready for hearing, recessal list the matter for hearing on
In the month of May, my
in
lord.
the month of May. In the month of
Date may be fixed, my lord. 15 May.
15th of
Much
May.
obliged.
In terms of this IA stands closed. Mr. Barbuya, you go and inquire from the registry
Well,
why the matter is not.
May I pray, since it is a 2017 matter, it may be listed before the top of the list.
That they will share.
I am appeal, I have also urgent in nature for final hearing.
Okay.
I am not opposing, but learned friend
Much obliged.
submission other ways.
Number 38 by VC Moore. It is a lordship, this is an application for compromise settlement, lordship. The parties have amicably settled the case at 19 lakhs. And out of that 19 lakhs, 10 lakhs, 3,151 was already paid. on 2/8/2024. Now, what remains to be paid from that settlement is 8,96,849.
My lord, I am appearing for the respondent number 1, Lordship, and the claimant. Lordship, there is an out-of-court settlement between the insurance company and the claimant, Lordship. Although the original award was high, but it has been settled at
19 lakhs.
Original award was
Original was 20 lakhs, Lordship.
20 lakhs.
20 lakhs. 20 lakhs, 2,000. 20 lakhs, 6,302.
In which paragraph you have mentioned it?
Lordship, it's in para number 2 and 3.
So, Mr. Dasa, the matter has been settled.
Yes, Lordship. I have checked in the registry also, Lordship. 10 lakhs, 3,151 has been already been deposited, Lordship. The remaining amount of 8,96,849 that is required to be deposited, Lordship. This will make altogether 19 lakhs, Lordship, in the registry, Lordship. And thereafter, the claimant may be allowed to withdraw, Lordship.
Heard Mr. R. Goswami, learned counsel for the applicant, and Mr. D. Das, learned counsel for the respondent number 1.
One, Lordship. One claimant.
Respondent number 1. This interlocutory application is preferred by applicant Magma HDI General Insurance Company Limited. Jointly with the respondent number 1
Lordship.
for compounding the case, compounding the MSC appeal number 356 of 2024. It is submitted at the bar that the learned tribunal has awarded a sum of rupees. Where it is mentioned, Mr. Goswami?
It's in the award, Lordship. It's not.
Where?
This award is it.
No, in the application you have not mentioned it.
Application to mention it, I have not checked.
Okay. Has awarded a sum of rupees 12 or 20 lakhs 6,302 rupees, being the compensation with interest at a rate of rupees 7% per annum. From the date of filing the claim petition, that is 23rd 11/2022 in MSC case number 504 of 2022. It is also submitted at the bar that the parties have effected a compromise and decided to settle the matter on payment of rupees 19 lakhs in all. Whether the interest part is incorporated?
That's in all, Lordship, everything, all inclusive. It's inclusive of interest and in all. It's written very, is as full and final amount. This balance
Claimant
amount.
is also in, claimant is urgent. Claimant is in urgent need of money, Lordship. That's why she is compelled to settle, Lordship, in a lower amount, Lordship.
No, Mr. Goswami, is this the way of?
No, I think it's a very liberal settlement, Lordship. If I'm right now, we are not on merit because we have gone for a settlement. We have filed a petition, but I'll explain. Just my friend will not mind it. He's not even 18 years old. What is the claimant? It is 20 lakhs, which is on the comparatively is on the much on the higher side. So only 1 lakh has been reduced and with interest, it has come to 19 lakhs. Not even 18 years. It's supposed to be 18 years. Maharaj says it was 35. Probably he is less than 18 years. So from that point of view, by the prevailing trend, it's a very liberal settlement.
But is this the way of settlement of the claim?
Yes, Lord. It's done even in local that it even goes sometimes even settle a lesser amount. This I consider to be a very good, healthy, liberal settlement. And I don't usually encourage lower settlements unless it is any unethical settlement. This is
No, you may encourage, that's all right. It is in the interest of your party.
that is a fair settlement. I would try to say it's a very fair settlement. I can even press it on contest. Probably I'll get a lower, better settlement. Award. But they also.
$19 lakhs as full and final settlement. Full and final settlement. And therefore it is contented to allow this application. Taking note of the submission of learned counsel for both the parties and also considering the facts and circumstances of the record, this interlocutory application stands allowed. The MSc Appeal number 356 of 2024 stands disposed of on the strength of compromise. In view of the settlement arrived at by the parties, now the appellant in MSc case number 356 of 2024 shall deposit the remaining amount of
8,96,849
rupees in the account of the respondent number 1 within a period of Mr.
Lordship,
Das.
Lordship, it is the earlier amount was deposited before the registry, Lordship. So this amount may also be deposited before the registry. On due identification, the registry may
Why not?
transfer the amount to
No, Mr. Das, why not in the account of the
No, I have no objection, Lordship. I have no objection in that
Yes,
way
you,
also.
deposit directly in the account of the respondent.
Lordship.
It is an order of the
Deposit the amount. Then what about the other direction regarding this fixed deposit?
that has to be should be an order for refund of this. It's usually refunded after on payment. The registry verifies whether payment has been done, then it's refunded. If this order is done.
They'll directly deposit the tip in the account of the respondent number 1. By direct transfer mode. Within bracket NEFT. And from the amount already deposited before the registry of this court, that is, what is the amount?
25,000.
No. Before the
10
registry.
10 lakhs, 10 lakhs, 3,000.
10 lakhs, 3,151.
10 lakhs,
3,000.
151. The fixed deposit as directed by the learned tribunal at paragraph number 29 of the impugned judgment and order in MSc case number 504 of 2022 shall be carried out. And the remaining amount after fixed deposit shall be released in favor of the respondent number 1 after proper identification.
Lordship.
Terms of above this IA and MSC appeal number 22 stands disposed of.
The statutory depositors. Refund of statutory.
Mr. Goswami submits that at the time of filing the appeal before this court, a statutory deposit of rupees 25,000 was made before the receipt of this court, and the same may be released in favor of the appellant herein. Here is accordingly allowed, restitution allow the appellant to withdraw the amount.
Obliged.
39.
I'm obliged. Lordship.
Yes, Lordship. Lordship is I is for condonation of delay of 60 days, Lordship. Defined the calendar MSA April. So notices may be
Delay of
60 days, 60.
where you have mentioned it.
In the page number 2, Lordship. Of IA.
Page number 2.
Page number 2.
Where? In which line you have mentioned it, sorry?
Just above in the matter of in capital, Lordship. If Lordship may.
Is it there?
Yes, Lordship.
Next.
I consult.
40.
May it please your Lordship. This is an IA for condonation of delay of 109 days is connected match appeal. At this stage,
Okay,
notice will be issued.
we will issue notice. After 4 weeks.
41.
Please, Your Lordship. Lordship, we have filed an IA for early hearing, Your Lordship. Lordship,
Whether you have served notice.
Lordship, no, service is already completed. LCR has also been received, but the respondents are
No,
not
about
yet-
this application, interlocutory application.
No, Your Lordship, no notice. This is the first time Your Lordship has come up.
Heard Miss
FN Jaman on behalf
Learned
of our
Counsel for
children.
the applicant. This interlocutory application under section 151 of the Code of Civil Procedure is prepared for early hearing of RSA number 59 of 2019 pending before this court. That notice be issued returnable in 2 weeks. Step be taken by registered post with AD and also by usual process within 2 working days from today, at least after 2 weeks.
Alright.
59.
After 4 weeks, step within 2 working days from today.
Obliged.
19 billion.
Wait, please, your Lordship. My Lord, earlier this application was rejected by your Lordships on 6/2/24, my Lord. Now, my Lord, in the FIR there is nothing, my Lord. Now, if your Lordship kindly comes to the forwarding report at page 16.
Yes.
Now, my Lord, brief history. Now, please come to para 8. During investigation, a letter was sent to Circle Officer, Dispute Revenue Circle, for seeking the status of the land and to Deputy on Lat Mandal for spot verification. Accordingly, a report from Circle Office was received, which has enclosed herewith with the case diary. In the report, it is mentioned that as per local people's statement, Nobo Patwari was filling the art at Dag number so-and-so, and Nobo Patwari is not partner of the said plot of land. Furthermore, Dag number 191 and Dag number 195 were arises from old Dag number 67.
All the above, during investigation, it is established that Amir Hussain, son of late Dulumia, got power of attorney from Govindo Deka for the land having patta number so and so. And Amir Hussain, along with Nizam Bosumatri and Nabopaturi, were filling art at the plot of land having Dag number 195. After going through the case diary, it is noticed that land patta number and Dag number were not mentioned in the statement of the complainant of the case, and also found puzzle the Dag number, patta number in the FIR. Therefore, I remain attentive to the call of the complainant of the case for re-examination. The complainant of the case is re-examined as well as his relatives and recorded the statement under section 161 CRPC. After re-examination of the complainant of the case and his relative, it is known that allegation is not only under section so and so, but also under section so and so against the alleged accused person. After thorough checking of the document which was seized by the previous IO of the case and found the following. In deed number 4865, Narayan Chandra Mohanto and Keshav Chandra Boisya purchased 10 kotha each, 3 kotha, total 3 kotha from Prashanta Kumar Goswami. But in the deed dated number so and so, Godhuli Deka purchased 2 kotha 10 lesa from Keshav Boisya. A question arises here: if Keshav Boisya purchased 1 kotha 10 lesa as per deed of so and so, how could he sell 2 kotha lesa to Godhuli Deka? Whereas there is no any deed shown in between Narayan Chandra Mohanto and Keshav Boisya from 71 to 92. Therefore, Keshav Boisya could not sell 2 lesas to Godhuli Deka, which indicate that deed number is fake as claimed by the complainant of the case. Now, this has got nothing to do with the petition. Seen, enough of confusion is there, Milord. As far as we are concerned, Milord, by a sale deed at page 32, and relevant is at page 36, I purchased, Milord, from Nabo Patwari. Now, if your lordships kindly comes to page 36, the schedule of the land, a plot of land measuring 3 kotha covered by Dag number 195, 186 and KP Potta number 886 and 88. Now, as far as the FIR is concerned, the FIR concerns my lord Dag number 888 and KP Potta number 191. So therefore, my lord, I do not know, my lord, how I am involved in this case.
No, 888 is also there.
No, 888 is the Dag number, my lord. If your lordship kindly comes to the FIR.
No, 888 is patta number.
No, my lord, my lord, the land.
36.
Yes. The land which that is the patta number, my lord. Patta number 886. And kindly see, my lord, the FIR involved is Dag number 888, patta number 191. So the IO himself is confused, my lord, because Godhuli Deka, Keshav Boisya had 3 kotha, sold more than 3 kotha. Now, if your lordship would kindly come to the Assamese version of the, my lord, at page 14, Ezahar, Hanmanpurvak Binito Nivedan Janiba Moor Deutar Namot Thoka Sorgyo Narayan Chandra Mohanto Miadi so and so Haukusi Sohor Dag number 888 Pottan number 100 Matiloi Jua Sorkari Batu Kuno Osinaki Luke Bondo Kori Deu Goise. Are he Huzugote Kuno Osinaki Luke Ukto Matikinit Mati Pelai Dohol Korar Sesta Koris. Well, I have got no connection with Dag number 888 and Potta number 19. This is the situation. Because from the Milord forwarding report, while forwarding the arrested person, the IO's view himself seems to be very confusing, Milord. In any case, Milord, I have got nothing to do with those allegations. Only thing is, I purchased from Nabo Patwari. End of the day, Milord, I think civil suit pending. I think eventually, Milord, these issues will have to settle by civil suit, Milord.
But these kind of offenses are frequently going on.
Nowadays,
Wow.
yes, that is also there, my lord. That we do not dispute, my lord.
Okay,
My lord, my humble view is, my lord, there has to be a holistic change of approach, my lord, right from top to bottom. Somewhere, if we pick up somebody from the nothing is going to happen. There has to be a drastic change of approach towards everything, my lord, because nowadays we have all become so self-centered. Things have become very difficult. My lord. My lord, when we go to offices, they don't work. If we expect them to work, then we must part with something. That has become a reality, my lord.
Okay, we'll see the case diary.
Yes. Deeply obliged.
Lordship, item number 25, your lordship. LCR has been received, your lordship. Service is also completed here, your lordship. Respondents are not appearing, your
This
lordship.
IA is for what purpose?
Lordship, IA was for stay, your lordship, stay of the operation of the judgment and decree dated 3/8/2019, which was passed by the learned civil judge Honitpur, your lordship, in title appeal. My first appeal was dismissed, your lordship. Suit was for recovery of possession. I am for the defendant, your lordship. Suit was for recovery of possession and ejecting the defendant and for the possession of the rice mill that is situated in the suit land, your lordship. They were supposed to file their objection, your lordship.
P. Chakraborty, কবে দিলেও contract?
Lordship, then a short date may be fixed, your lordship.
Hard miss.
FN Jaman on behalf of R.
Learned
Chaudhary.
counsel appearing on behalf of R. Chaudhary, learned counsel for the applicant. Non-appeals for the respondent number 1 can be on call. Place the matter after a week. In the event of subsequent non-representation of the respondent number 1 with 3, appropriate orders will follow.
Lordship, but date may be fixed for a week.